May.
Yeah, mention.
May I please, Your Lordship? One regular bail application, Lordship, filed on 1st of April, Lordship.
For listing.
Come on tomorrow, Lordship.
Okay.
Their Lordship on filed on 2nd of April.
Listings allowed.
Listing tomorrow,
States,
Lordship.
sorry.
May I please,
Mobilize.
your lordships? I need little accommodation, lordship, in item number 48, lordship. As Gauhati High Court Legal Services Committee, today morning informed me, I have to appear for respondent number 2, lordship. But
Okay.
appointment letter yet to
Okay.
issue, lordship,
After vacation?
after vacation, lordship. I have informed the opposite party, they have not given me consent. It is, I have informed them already.
That's- So should we wait or
I need accommodation now, lordship. I need to go and.
just write it down? Yeah, 6 and accommodation. Your good name, please, madam?
RB Bora, Rita Boro Bora,
RB for
Legal Aid Council.
has been appointed for as legal aid counsel by the Gauhati High Court, by the Legal Service Committee of this court for the respond number 2. Only today.
Only
You-
today.
Appointed, and she has received the same said order only today, and therefore prays for listing the matter after the vacation. Fixed on, we'll fix it immediately after the vacation.
Lordship.
20.
Appointment letter yet to receive, but verbally inform me.
Verbally informed. Just write it.
Deeply obliged.
We'll fine tune this order. Let them come.
Please, Your Lordship. Please, Your Lordship. Lordship, I beg to mention item 44 and 45. These two matters are supposed to be listed in motion column, has been listed in the bail hearing. But anyway, Lordship, here Lordship report would be necessary, Lordship, because it's bail filed under anticipation. So that may be fixed on 20th, Lordship, along with report.
The report.
Yes, Lordship.
Okay.
44 and 45.
Earlier matter was only adjourned, my lord. Earlier
That's
listed on 33/26.
Yes.
So I'll just adjourn it
Okay.
and fix it on.
Lordship, report would be necessary along with report from the concerned police station.
Concert police station.
Yes.
List on 28th. 20, along with the report,
Both the matters. Item 44 and 45.
44 and 40. Report is not received.
Not-
Issue
May-
call for the report, list along with the report on. Yes.
May I please, your lordship? Lordship, I beg to mention item number 52.
15,
52, lordship. Supplementary list,
5,
2, lordship.
52.
Lordship matter may be allowed to.
So it will be called out. Be called out. After the motion, it will be called out. Okay.
May I please, Your Lordship? My lord, I beg to mention item number 27, Lordship. Lordship, I have taken consent of other side, Lordship. Lordship, this matter may be kindly taken up in the first week of May, Lordship.
Mr.
N.H. Borhuya.
NH Borville submits with that with the consent of the other side. The matter may be adjourned today and fixed in the first week of May. Prayer is allowed. List, should we fix a date or leave it to
My
rest?
lord, first week of any date, first week of May, Lordship.
List in the first week of May on a date to be fixed by registry. Any interim order?
Interim order.
Interim order stands extended till the next date of list.
Highly obliged.
Lordship, I beg to mention item number 33, my lord. In this matter, my lord, trial court record was called for, but record was received only on Saturday, my lord, last Saturday.
Mhm.
So kindly it may be called for, my lord, today,
Report may be got.
my lord.
Okay,
From
you're not seeking adjournment.
No, my lord.
The report may be called.
But,
Sir, take it.
today itself. Obliged, my lord.
May it please your lordship. Lordship, I beg to mention bail application 933/2026. Lordship, the matter was supposed to be fixed today, that is 6-fold. But according to the order, it has been fixed on 24-fold. That is after Bihu vacation. So I beg to mention the matter may be come up tomorrow, your lordship.
Tomorrow.
Yes, for CD it should be come.
The date has already been got
Mentioned
fixed.
24-fold, but it should have been fixed today. As per the verbal dictation of your lordship.
I see. Probably it's okay. Let it come.
Almost.
May I please, your lordship? I beg to mention item number 43, your lordship. 43.
Yes. After vacation,
Actually, I think
My lord, case diary not received, my lord. He is in.
CD may
issue
kindly
reminder
call
for
for.
the case diary not.
I'm not
issue
interim,
reminder-
Your Lordship.
issue
Kindly,
reminder
Your
for the
Lordship,
case
on
diary.
20 or 21, Your Lordship.
Oh. It will be on 20,
20.
21.
21, Your Lordship. Oblige, Your Lordship.
May I please? Yes, I beg to mention item 36 of today's list.
No.
CD was called for,
Mhm.
accused in interim. As per instruction, CD is lordship not available. 36 CD not received, my lord.
CD not received, issue reminder. Interim bail stands extended till the next date of listing. Should we suggest a date, please?
My lord, on 5th of May, my lord.
Five.
Obliged, lordship.
May I please, Lordship? I beg to mention item number 34. And today CD was called for, but charge sheet has been filed.
CD was called.
It is for CD. But
As per my instruction, charge sheet submitted in this case.
We can dispose it off instead of adjourning it. Okay, let the matter come up.
May it please your lordship, I beg to mention item number 39, prayer for adjournment.
39.
Item number 49 CD not received.
Right? Issue reminder for the case diary. Interim is there.
Interim is.
Interim stands extended till the next date of
No,
listing.
my lord, one is not CD, my lord, one report, my lord, regarding.
Report has called for noted receipt. Also issue reminder for the same interim order. It will be. Interim order stands extended till the next date of listing. Then you fix it in the last week of April,
Yes, well,
30th April.
yes, ma'am.
30th April.
Obliged.
I think lordship. In item 12, lordship, may I pray for other day, lordship?
12.
Lordship.
Motion. Your choice.
Well,
Yeah.
Mr. When?
Lordship.
After which
After vacation, lordship.
adjourn, 6 and adjournment for the matter. List on 21,
Yes, please.
21, 22,
What's in?
22, 22, 23.
Oblige, lordship.
May I pledge your lordship? I beg to mention for withdrawal of bail application for, as per the instruction of the petitioner.
Which one? Is it listed today?
No,
You want to get it listed for, you want to make
withdrawal, I want-
oh, tomorrow? List it for tomorrow. I think,
yeah, withdrawal for.
yes, tomorrow. The upon not finding sufficient merit in the interlocutory application, the same is dismissed at this stage. I stands disposed of.
Item number, no, judgments, delivery of judgment. Please.
At least is to you. Then I got the sign for this one.
Letter 51.
Withdraw the matter.
Yes, lord.
Dismiss.
Yes, ma'am. Your good name.
Yes, my lord.
S. Yashmi, the learned counsel for the petition, submits that they have instructions to seek withdrawal of this criminal petition. Prayer is allowed and the instant cases disposed of upon withdrawal.
Lordship, liberty may be given to file a fresh criminal petition, lordship.
Further, the petitioner seeks liberty to file a fresh petition. Liberty is allowed.
Highly obliged, lord.
Lordship, I may be allowed.
Withdraw. L.R. Majumdar, just like 6 withdrawal, 6 submits that he has instructions to seek withdrawal of the bail petition. Prayer is allowed, disposed of on withdrawal.
Obliged. Upon the item number one.
Yeah.
Yes, Lordship. So when it is the Lordship, actually it was an accident that Lordship. But section 109 put the Lordship. And it was the FR vernacular case 14 Lordship. Only motor accident Lordship.
I'm seeing there is a harm. Anyway,
Yes, Lordship, section 109, not attack Lordship, is a mechanic by profession Lordship. Doing that tell riding Lordship, he suddenly hit the injured Lordship. After 18 days, lost this FR Lordship. As a Lordship, 40 days.
Your Lordship, may kindly last portion of the forwarding report, my lord. He before that accident, he disclosed before
Nothing,
one Ainul Haq.
that's anyway, let us see
Yes.
the case diary. Kindly give me a date immediately after reopening.
Lordship, only short time, you know, as a 40 days Lordship.
Yeah,
From Baida Sari Lordship.
diary has to be sealed.
40 days Lordship.
A.K. Ahmed, Lanet Council. Reporter. Call for the case diary of Baihata Sariali PS case number 41 of 2026 under such. And so the petitioner is in custody since, stated to be in custody since 26 to 2026. List on
On 24 to 22/4.
22.
Obliged.
May I please your lordship? Lordship, 483 application of my lord, BNS my lord, allegation under section 318(4), 316(2), 314, 296 and 351B my lord. As on that petitioner is in custody my lord for last 20 days my lord. Lordship may peruse the FIR my lord as page 20, particular person is at page 22 my lord. Basic allegation, may I read my lord? Basic allegation is that my lord, petitioner had taken rupees 15,000 from the informant and another 15,000 from one Abdul Rauf by giving assurance that he will provide them home guard job. When the present petitioner are unable to provide them home guard job, my lord, the informant returned back the money. Then the present petitioner threatened them that they would kill them if they return back the money. This is the basic allegation, my lord. For which, my lord, this present FIR was lost and registered, my lord. Actual fact is, my lord, quite different, my lord. The petitioner and the informant and Abdul Rauf, my lord, on good friend, my lord, paragraph 4 I have mentioned. For his business purpose, my lord, the present petitioner have borrowed 50,000 from each, my lord, total 1 lakh from this present, my lord, informant, my lord. Thereafter, my lord, when the informant lost the FIR, approached the Borpeta police station, my lord, he had already paid, my lord, the alleged amount, my lord. That lordship may kindly peruse, my lord. At page, my lord, 20, particular portion is at page 22, my lord. Present petitioner had already paid rupees 1 lakh.
1 lakh was recovered from him according to the forwarding report.
Lordship, already recovered and
Recovered from him during investigation.
not recovered, my lord. When police detained this present petitioner, my lord, police directed me that you give 1 lakh to the informant, I will release them. Accordingly, my lord, the petitioner give them the money. Police seized that 1 lakh's money, my lord, from the present petitioner.
Anyway, so
So, my lord, my respectful submission, my lord, page 28, my lord, paragraph 21, rejection order, my lord. Lordship may kindly peruse, my lord. Further, may I read, my lord?
I'll go through. Page,
Page 28.
I'll go.
It is clearly, my lord, reflected, my lord, order of my lord JMFC, my lord. On going through the seizure list, 5 MR case number 73/2026 is produced by the IO. It is seen that the case amount rupees 1 lakh has seized in connection with this case, my lord. So petitioner had, my lord, paid the money to the informant, my lord.
So the thing that the home guards have a gap of 6 months, you know,
Yes.
so that this is a common, they say it's a common problem that they are asked for money and for to re-engage them. It's a
Yes.
big problem.
Yes.
Said to be a big problem anyway, but many other people also make use of that, you know.
Yes,
And-
yes,
and
that is the
without,
difficulty. Yes.
they they wrongly try to, get some money. Anyway, let us see give it on 28th.
Yes, please.
Immediately on reopening.
Yes, please.
Corpeta PS case number, heard Swenson. Corpeta PS case number 82 of 2026. The petitioner was arrested on, when was he arrested?
Petitioner was, my lord, detained on 15/3, my lord, by police, my lord, arrested on 15/3, but he was forwarded, my lord, on 18, my lord. From forwarding report, my lord. Lordship may kindly peruse, my lord, forwarding report, Kiman Pelsi.
The FIR is on 17.
FIR is on 17. Prior to that, my lord, one FIR was not, that FIR has been withdrawn. Police has arrested this present petitioner on 15, my lord, 15/3, my lord.
We'll write it later. This is the matter on 20th April.
Yes.
Obliged, my lord, deeply obliged.
Number 3. May I please your lordship? In this case, my lord, FIR page 7.
Yes.
Translated copy, my lord. The accused person arrested on 25/2/2026, my lord. Today, my lord, 40 days, my lord. I am in custody, my lord. In this affair, my lord.
Cash is not recovered.
Some
Stolen
unknown
from,
person
oh,
taken money from the informant, my lord.
they,
My name is not in the affair, my lord.
From CCTV footage, my lord.
CCTV
Ground
footage.
program
The
forwarding report
forwarding.
14 and 15, my lord.
Earlier, 2 times, my lord, I have filed bail petition, my lord. One SDGM and session, my lord, both are rejected, my lord.
Anyway, ground so.
He's a member of Irani gang. No.
Anyway, so, heard, call for the case diary of Bogri Bari PS case number 8 of 2026. The petitioner was stated to have been arrested on 25/2/2026. List on
On 23/4.
23.
Hello.
Right, it's a my lord, charge-sheeted bail application, my lord. Charge-sheet filed, my lord, against the accused, my lord, under section 317 of 2, my lord. Case is in, my lord, appearance stage, my lord. I am behind the bar, my lord, since last 47 days, my lord. We have also been fined, my lord. The FIR is at page stage, my lord. Allegation is, my lord, theft in a jewelry shop. And all the articles were, my lord, recovered, my lord, and thereafter, my lord, Bima was also granted to the
Alleged theft in shop,
Yes.
jewelry shop.
Jewelry shop, my lord. Some silver article, my lord. Silver ankles, etc. were, my lord.
It will be wise to see the merits.
Yes, scan copy of PCR.
Considering, my lord, nature of offense, my lord, it's a, my lord, maximum punishment is, my lord, 3 years, my lord. Punishment for theft, my lord. I am also, my lord, not naming the
Stealing of,
offense.
theft of jewelry.
Jewelry shop, my
Lot
lord.
of jewelry from jewelry shop.
Yes, my
Anyway,
lord. And
let's see this.
all items were recovered, my lord, and subsequently Jimma was also granted, my lord. I am behind the bar since my last 48 days, my lord.
Call for the scanned PCR comprising case diary, charge sheet, and other 11 documents. Of it is trial has started
Lordship, my lord.
of sessions case number 21 of 2026 within bracket GR number 39 of 2026 arising out of Gosaigaon PS case number 35 of 2026 from the court of the learned special judge,
Additional session judge,
Sorry.
Kokrajhar.
additional session judge Kokrajhar. Also, list on 23,
Yes,
23/4.
20.
23.
Obliged.
Yes, that's what.
It's a regular bail application, my lord. Here, my lord, attempt to murder section has been attributed, my lord. Only thing here, my lord, Lordship, kindly, that diary would be possibly necessary, my lord,
Investigations going on.
and but there is violation of that, my lord, 36B1, my lord. So kindly any date in the, my lord, after the reopening,
Reopening.
early date, my lord.
Call for the case diary of Nalbari PS case number 45 of 2026. The petitioners were arrested on 10/3/26 and 12/3/2026 respectively, are stated to have been arrested. List on 20th,
Yes,
20,
My,
after reopening, on the day of reopening?
21st, my lord.
21st.
It may not come on.
Okay.
Obligement.
21/4.
Made your lordship. In this matter, my lord, the petitioner is the lady, my lord. He is behind bar for last 67 days, my lord.
57 is
Allegation is on suspicion, my lord. My lord, allegation is that, my lord, she has conspirated with another person to kill her husband, my lord.
Against, sorry, miss.
My lord, FIR is at page 9.
Yes, yes, I'm reading sometimes. Who's the petitioner? He was arrested during investigation.
My lord, she was arrested on 30th of January, my lord.
She is the second wife of the
Second
deceased.
wife of the deceased.
Deceased.
Investigation is going on.
Going on.
Yes.
Diary will have.
My lord, shorted may be given, my lord. Immediate after petition.
After reopening. You can suggest a date from your side also.
My lord, preferably 28th on reopening day.
28th or immediately or
28
1 or 2 days here and there.
22.
Call for the case diary of DFU PS case number 1 of 2020. Petitioner was arrested on 31/2026. 30th January.
22/4.
22/4.
22.
Obliged.
But this is a matter registered under the POCSO Act, my lord. So I'll pay at this stage, my lord. Scan copy.
Investigation or?
Oh, no, trial is going on.
Trial is
Already 4 witnesses has been
Okay.
examined. 5 witnesses has been
Okay.
examined, my
Scan
lord.
copy will be
Thereafter, we are
necessary.
before your lordship.
Call for scan copy.
Because. And then after review.
Yes,
Sir?
sir. Notice may also be issued.
State Command and Senior Counsel. We both have to first. And Senior Counsel fairly submits that this case perhaps scan PCR may be called for. So, notice has to be issued. No?
Yes, my lord, notice has been.
Steps of
Actually,
notice.
notice if your lord will permits me, my lord, he is
SI
the police officer.
Police officer.
Gorchuk, OC's person, police station.
No.
No, first title please.
Issue
So if he wants, he can also accept.
steps of notice. Can we just let us do the formality in the.
But he'll
Steps
take
of-
steps, my. Huh?
Steps of notice upon the respond number 2/inform shall be taken to the office of the public prosecutor and to be executed to the concerned police station. Call for the scan PCR of special sessions case number 217 of 25. Arising out of. Just write the.
Arising out of Gorchuk PS, my lord,
Gorchuk PS
269
Gorchuk
of
case number
225.
269 of 2025.
25, my lord.
269 of 2025 in the court of the learned
Why?
special judge POCSO Kamrup M. Gauhati. List on. When you do. prefer.
Well, can it be on 21, my lord, because 21 holiday, my lord, will be here.
21.
21, much obliged. Gorchuk.
ঠিক আছে দিয়ক তুমি চাই দিয়া
English person was arrested on 28th February 2026.
So item number seven?
Huh?
item number
53. Particular is it page number 19, your lordship.
Investigation case is going on.
Lordship.
Investigation is going on.
Yes, right. But the accused person may read the FIR. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ পত্নী আছিদা বেগমে আজিৰ পৰা প্ৰায় ৩-৪ বছৰ পূৰ্বেই আমাৰ ঘৰ এৰি থৈ তেওঁৰ মাকৰ ঘৰলৈ গুচি যায় আৰু তেতিয়াৰে পৰা আমাৰ লগত কোনো ধৰণৰ সম্পৰ্ক নাছিল। শুনিবলৈ পোৱা মতে মোৰ পত্নীয়ে মাকৰ ঘৰৰ পৰা অন্য এজন যুৱকলৈ বিয়া হৈ ঘূৰি আহিছে। এই খবৰ শুনিবলৈ পাই আমি তেওঁৰ লগত ভৱিষ্যত কোনো ধৰণৰ সম্পৰ্ক নাৰাখো বুলি প্ৰতিশ্ৰুতিবদ্ধ হওঁ।
কিন্তু আজি প্ৰায় কিছুদিন আগতে মোৰ পত্নী আছিৰা বেগমে আকস্মাতে আহি আমাৰ ঘৰত ওলাই আৰু ঘৰৰ দৰ্জা ভাঙি ঘৰৰ ভিতৰত প্ৰৱেশ কৰে আৰু এয়া মোৰ মায়ে কোনোপধ্যে মানি লোৱা নাছিল। এই কথাৰ বিৰোধিতা কৰাত উক্ত আছিৰা বেগমে মোৰ মাক বিভিন্ন সময়ত বিভিন্ন ধৰণে শাৰীৰিক ও মানসিকভাৱে অত্যাচাৰ চলাই আহিছিল। অৱশেষত তেওঁৰ অত্যাচাৰ সহ্য কৰিব নোৱাৰি যোৱা 18/1/2026 ইংৰাজী তাৰিখে মোৰ মায়ে আমাৰ ঘৰত চিপ জড়িত আত্মহত্যা কৰে। Thereafter, your lordship, this FIR was lodged on 24 January, your lordship. The fact of the case, lordship, that the petitioner got married with the informant lordship in the year 2019, and after few months of her marriage, your lordship, she was subjected to domestic violence. And thereafter, lordship, after giving birth to a male child, she left the house of the informant lordship, and since then she was residing at her parents' house, your lordship. Thereafter, on 19 lordship, on 18 February, 18 January lordship, the petitioner's mother committed suicide, and she got the news lordship on 19 February lordship, and accordingly she went to the house of the informant to consult the family of the deceased lordship. And thereafter lordship, when she reached the house of the informant, she was misbehaved, and that resulted into an altercation, your lordship, and she returned to her parents' house, your lordship, and thereafter this affair was lodged on 24 February, making this false allegation, lordship. And thereafter, the accused person was arrested, lordship, on 28th February.
28th February.
Yes, your lordship. 28th February, she was arrested, and at the time of her arrest, of your lordship, the proper procedure of law was not properly followed. If your lordship may come at page number 21, your lordship will find the arrest memo, your lordship. In the arrest memo, lordship, there is no signature of any witness, lordship. There is that was not countersigned by the accused person, your lordship. And thereafter, lordship, the accused person was remanded to judicial.
I think Asita Begum, no? Asita Begum.
Yes,
Asita Begum.
Signature of arrested person is there. For witness, he said, witness. Where
Not
is the
the
witness column? Date of.
Signature is not there, your lordship. Page number 21, lordship, arrest memo. Signature is not there.
No, on the next page, what is this? Next
This is your lordship,
47.
section 47 notice, your lordship.
place of arrest, date of time of arrest. There's no column here. How come there's no column here with regard to the signature of the arrest?
Thereafter, lordship, accused person was remanded to judicial custody by learned Chief Judicial Magistrate Kamrup. That remand order is I have annexed page number 26, lordship. Your lordship will find, if your lordship may kindly allow me to read the second two paragraph, lordship. Seen the accused person also seen the seen and perused the forwarding report, arrest memo, inspection memo, notice under section 47 and 48 of BNSS, the detailed ground of arrest communicated to the accused person in Assamese language, lordship. But your lordship, if your lordship may kindly come at page number 22 and 23, section 47 and 48 notice, lordship, ground of arrest was communicated with the accused person in English language, lordship.
Ground of arrest was communicated
In English, lordship. But in the remand order, it has been written in, it was communicated in Assamese language, lordship.
Accused person has also made her signature in English, no?
She's studied till class 10, lordship. She do not understand English,
must
lordship.
have been explained, but there should be an endorsement in the case diary that
Yes,
was
ma'am, at
explained
least-
to her
Yes.
in Assamese. Bilingual is best.
Yes.
Best is bilingual, but if it is not, at least there shouldn't be an endorsement in the case diary that those typed in English but explained in English. That's why we have to only from the case diary.
Yes.
But there's a problem is that when she was arrested on 20th,
She was 28, lordship.
28 or 20,
28, lordship. 2802.
20,
28 February, lordship.
28th.
28.
28 February.
She has been behind the bar, your lordship, more than 30 days. And the proper procedure was not followed. Not
Today is only 37 days, madam.
Immediately, because there's a vacation in between, that's a problem. Otherwise,
Yes.
which thana, this one?
Sanctuary PS.
PS, madam.
So you would
Your
have
lordship
come
may fix it on 23rd or 22nd. madam.
immediately after reopening, immediately,
Yes, yes.
on 20th. CDs will come, no, on 20th? Will come,
20th, immediately on the day of vacation, it will be your lordship on
21.
21.
Heard call for the case diary of Tansari PS case number 15 of 2026 on the joint section. The petitioner stated to have been arrested on 28/2/2026. The earned counsel submits that the allegations in the FIR are concocted, distorted, and concocted and distorted. Full stop. It is also submitted that there are infirmities in the notice under section 35 BNSS. As also the notices under 47, 48 BNSS as the same weight in English language.
Arrest memo was also.
I'll just for reference. List on 21.
Wait, please, Your Lordship. The regular bail application, my lord. FIR, my lord, is at page number 20.
Is that in the stage of trial?
Trial stage, my lord. May I read the FIR? Basically, my lord, if I may sum up, my lord, out of 8 witnesses, my lord, 7 have already been examined.
Sure.
And Lordship will kindly see the last witness at page number 56. Last witness was examined on 21st June 2024. And since then, my lord,
No, nothing.
they have not been able to examine any other witnesses, my lord. And the petitioner, my lord, has completed around 597 days in custody. And Lordship may also see 2 things, my lord, page number 27 and 28.
Notebooks.
Present status report may be called from
28 and 29.
What is it pertaining to?
Attempt to murder, my lord. No special sections are there, my lord.
Attempt to murder.
Attempt to murder.
Let us see the FIR once.
Yes.
What did you say?
Well, otherwise, my lord, present status report, my lord, of the case.
I have annexed all the documents, my lord.
And nature of injury.
FIR is at page number 20.
Charges have been framed against.
Witnesses implicated the present petitioner, nature of injury is grievous one. Witness. Doctor's report is also there.
Where is the FIR?
Page number 20, my lord.
25. Which witness is left now?
But IO is left.
Only IO.
IO. And my contention, my lord, is that, my lord, I am not on merit. Lordship will kindly see page number 28 and 29.
28 and 29.
29, my lord. Apparently, my lord, 47 and 48 were not complied with, my lord.
Seems so. If this is the only one, then it will not suffice, of course. At that time, this is the only one. There is no extension. Right?
Yes.
There is no. This is the only copy.
Yes.
Only page.
Yes. At that point of time, my lord, the police were also very much, my lord.
But in any case, I think.
And
what do you say? Trial is almost over.
yes.
Yes, but only.
Of course, if there is conviction, he has come back again. But then only IO is left.
Only I is there. Only trial is, my lord, almost. About
Since June, my lord, he has not appeared.
And doctor also examined, my lord, eyewitnesses also stated that he is the person.
They have
who
implicated.
Implicated. Injury is grievous, my lord. Everything is there, my lord, against the present accused.
And that's why I have annexed all the documents.
And at the fag end of the trial, my lord, taking that
Anything,
down.
my lord, regarding the merit, I am not submitting anything. My only contention is regarding non-compliance of 47, 48 and prolonged incursion. So, only those 2 grounds.
What is, my lord, scan copy of this year may be called from? I'll have to check the reports.
Scan copy may not be necessary.
Yes.
You can call for a status report.
Oh, yes,
Status
present
is
status
already there,
report
my
is
lord.
called.
Status for last order, perhaps I have already annexed.
Last order.
93/2026.
Page.
60
something.
66
or something.
67, 26/2.
67. This one, I think.
Yes.
Yes.
The trial is going to be concluded soon, so considering the Gauhati intro.
Third, S. Das learned counsel for the petitioner and P. Bhattakur learned. Stop. Invoking the provisions of 483 BNS. BNSS, the petitioner is seeking regular bail in connection with Dhubri PS case number 282 of 2024, which after completion of investigation has been registered into Sessions case number 343 of 2025, which is stated to be pending before the court of the learned session judge Dhubri at the stage of trial. It is stated that by order dated so and so, I had just seen that it's order, by order dated the charges were framed by order dated this one 12/11/2024. I'm just tagging it. Charges were framed against the petitioner under so and so sections. Drawing attention to the order dated 19/3/2026 passed by the learned trial court. The learned counsel submits that it is indicated therein that out of the 8 witnesses, 7 witnesses have already been examined, and the prosecution evidence is only pending for the examination of the IO. We have to cross-check this thing.
Yes,
So, but prima facie he has
yes,
made out, so we have to cross-check, but the whole TCR is not necessary.
yes, man. Only vital portion, man, along with the notice.
You have annexed copies of all the depositions, no?
Yes.
Certified copies of the depositions have already been annexed. Mr. Das learned counsel submits that he is not so much on the merits of the matter and has primarily 2 contentions. Full stop. Firstly, that the notices under section 47/48 have not been complied with properly. And secondly, the length of under trial incarceration ever since his remand to custody upon surrender surrender.
Arrest
Arrest or surrender.
was there, 27.
Okay, upon arrest on 16/8/2024. Full stop. It's also pointed out that the last witness, that is PW7, was examined on
21 June.
21/6/2024. Where was the notice of 47? Page
My lord.
23. The notice of, yes. The certified copy of the notice under 47 BNSS is annexed as Annexa 3 and may be reproduced here in below. It is at page 28. Just reproduce this. Okay, reproduce this. Next paragraph. It is settled that whenever a contention regarding non-compliance with these statutory notices is made, it would be for the prosecution to satisfy the court regarding that factual aspect. Nevertheless, since the case is at the stage of a trial, call for scanned copy of the notices under section 47/48 from the case record. Anything else? Depositions?
Yes, ma'am.
Status report? Not necessary. It
Yes.
is reflected in the
Not
order.
necessary, my lord. All
It is
everything is otherwise there.
Reflected in the order.
Everything is
Scan, only scan copy of the notices under 47/48.
Otherwise, my lord, in this case, when after obtaining that to be, in case of immediately after, he will be escaped from the My lord, there would be no possibility that he will again appear before the trial court for facing the, my lord, trial. My lord.
Will
That
he
is,
escape?
that is the main difficulty.
That
my lord.
argument will not sustain.
Yes, well, at this point of time, I am not.
That argument will not
Yes.
sustain because
May
it
not.
is a case of
Yes.
violation of fundamental rights, madam.
No, not really, because then in that case, we have to trust people.
Some strict
initially.
conditions, my lord. at that point.
Trust people initially. But otherwise we'll not be able to give bail. Anyway, so we'll call for this
Yes,
in the
yes.
meantime.
Yes, yes.
Based on the certified copy of the notice under 47, 48 BNSS. Prima facie, it appears that these notices fall short of the requisite standards as per the requisite standard vis-a-vis Article 22 within bracket 1, the Constitution of India, as per the governing law. Therefore, it is directed that in the interim, 50,000 with one surety, subject to the satisfaction of the Gauhati Session Judge Dubri and conditions, he shall not abscond. He shall be available for the remaining trial. Number 3, he shall not hamper or temper. Okay, we'll list it after vacation.
After
You
vacation.
can suggest a date, both of you.
My lord, on 5th of May, my lord.
5th of May.
5th of May.
Highly obliged.
Yeah, please, your lordship.
Yes.
Lordship, 482 bail applications. My lord, in this case, petition number 1 and 2 had recently opened a jewelry shop at Laktokia, Pennsylvania. So on, and petitioner number 3 is the nephew of petitioner number 1. So on 24th of March, what is it? The police team from a police team from Panbajar police station had raided his jewelry shop and found one staff member, that is Jyoti Paul. I have stated in my petition, and the concerned police has detained him, and the whole day had interrogated him on the allegation that this jewelry shop had received stolen gold ornaments from a thief. So after detailed interrogation, that Dibjyoti Paul, staff of this jewelry shop, was released and taken the number of this petition number 1 and 2 and 3 and given a call that they have to appear before the police station for interrogation. So in this regard, my lord,
There's no FIR as yet.
no FIR has been revealed. No information is there. But only this police is haunting these petitioners repeatedly, and their shops are closed now. So there is a serious apprehension of arrest in this case.
I can get the instruction at 2 also, my lord, whether any case will register, because these are the.
Since we have vacation,
Yes.
right?
My lord, in the meantime, I may be protected.
Just
because-
today, if it is today, then we can, we'll take out the matter again.
Well-
Then we can pass order if necessary. Okay?
At 2, my lord.
2, after 2 or after 2.
Yes.
Wait, Lord. Well, I'm praying for a transit period as bail, my lord, here. Well, what happened, my lord, the petitioner, my lord, he himself was a victim of a deception and the cheating, my lord, by 3 persons who induced him to get his Aadhaar card and open some bank account in order to get some employment scheme money, my lord. And he has given it, my lord. Now, my lord, when he went, he was asking them to return his passbooks and all. They did not return. He went to the bank and he has come to know, my lord, that his account was used for an offense, my lord. Immediately, he has lodged an FIR against them. Page 12, my lord, will kindly see. That was the notice, my lord, to the bank, my lord. From the bank, we have come to know, my lord, one of my account was used for some offense, my lord.
That's okay, but the thing is that what is the FIR?
Well, FIR, my lord, for that purpose only, my lord, I'm praying for a pre-arrest transit bail, my lord, so that I can go there, take steps for approaching the competent jurisdictional court, my lord.
Yes, because that is the, this is the FIR.
Yeah, no, my lord, this is a notice to the bank, my lord, where my account number is being mentioned, my lord.
Well, page 10, what is?
Page 10 is the FIR, my lord, by me against those persons
who opened the account, my lord, taking my Aadhaar card and my access to my phone, my lord.
Just a minute. Because, as you know, Priya Indoria, this case which
Yes, yes,
governs the law.
Yes, my lord.
One of the things that I have to satisfy the court as a petitioner is that why I have not, invoked the jurisdictional court, because it is not in another country, right?
Absolutely,
It is in the same country.
Absolutely.
And in today's electronic, communications, filing a case and moving it even online is not so much difficult. But sometimes there may be some difficulties, in which case this is to invoke, not not routine.
Yes, I understand.
So this
So
is the
this
notice
person,
you
but he is
received.
a 23 years old, my lord, he's a daily wage labor, my lord.
Cyber complaint investigation is carried out. Sent complaint was treated on the pretext of investment in shares and trades.
Basically, some information has been asked against the operation of this account, my lord. And my basic is, my lord, the FIR which I have lodged against those two persons.
In all these transit, Mr. Bhattakur, in these transit anticipatory bills, there are orders of our court.
Yes, your lordship.
That they have, for a limited period, it has been given sometimes on the first day or second day disposed of. But if you read the exact language of the conditions
Yes,
which are
yes,
necessary, one of them is that you have to give notice to the jurisdictional prosecution and the police. There some difficulties are being faced.
Yes, regarding that aspect also, once.
This also you can file. The
Yes.
thing is that, but jurisdictional prosecution, there are some difficulties are being faced.
Priya Indore, last portion, your lordship,
What do you say?
if I can remember, your lordship, I pointed out last portion of that paragraph, my lord, on the earlier occasion, that regarding that aspect, your lordship can only for a fixed period, my lord, a time frame can be fixed by your lordship, my lord. Only for appearance before the, my lord, not for.
Not keeping it pending,
Yes,
dispose it of.
yes, your lordship can dispose it of.
That has been done in some other orders.
Yes,
But if I remember correctly, it was, I think, probably said like this, that no order shall be passed without noticing the.
Your lordship,
So, my lord, that was
your lordship
basically
cannot
an
grant
argument
any
in that
interim
one.
protection, but only during that period, that period
Okay.
which,
It has to
during
be
which he
interpreted
can
like that.
approach, only during, for that period only.
It has to
Otherwise,
be
your lordship
interpreted
cannot
like-
grant any interim protection.
Because otherwise what will happen is that suppose because suppose I don't have jurisdiction actually.
Yes,
territorial.
your lordship
But
has no.
still, a small window has been given and
Yes,
for
only
certain
for a period that during
accident,
which he
this
can
is
for
given.
that.
Now the thing is that suppose some interim protection is given and he's asked to give notice, and he faces genuine difficulties to notice the prosecutor. He has to find out which prosecutor is there.
Yes.
And in the process, 1 month elapses.
Yes, ma'am.
So that will defeat the purpose.
Yeah,
of this.
defeat the purpose, yes.
So
And
that is the problem.
Yes, ma'am. And otherwise, your lordship cannot, your lordship cannot grant interim protection and ask the petitioner to appear before the arresting authority, because for that your lordship has no territorial jurisdiction. Your lordship can only, my lord, provide certain period so that he can apply before the, my lord, territorial court for granting protection, for getting protection, my lord. And that time, my lord, that is the my lord.
And what is your
That is
condition?
one of your
So I can dispose
How much
of on
can-
those lines. I
Yes.
can dispose it of.
Yes,
those.
yes.
So these orders have been made by a court also. So but this doubt remains in my mind, so I'm asking. It still remains, but I think relief has to be given sometimes
Yes, ma'am.
because
Now
that is
the-
becomes counterproductive.
Yes. Now
So-
only the question, how much time, my lord?
It takes time and it becomes
can-
counterproductive. This is what I've seen.
Yes.
So he's a daily wage earner.
Yes, yes, my lord. He's a 23 years young boy, my lord. He got trapped for getting some employment scheme money.
You're Mr. Kaushik,
Because
learned counsel for the petition. And P. Bhattakur, learned additional people. Invoking the provisions of section 482 BNSS, the petitioner is seeking transit anticipatory bail in connection with EFIR number 105 of 2026 dated 9/3/2026, registered at Cyber Police Station, Southwest District, New Delhi, under so and so sections. Full stop. Full stop. With regard to the same, it has received the notice under section 94/106 BNSS. From the state police station in Delhi, a copy of which has been annexed as annexure 2. Full stop. It is submitted that the petitioner is a daily wage earner, aged about 23 years, and he was due by some persons to part with some money and also details of his bank account with a false assurance of offering government scheme. But later he discovered their fraudulent activities. Full stop. It is stated that in connection with the same, he lodged a FIR before the Rongia PS on 18/3/2026, a copy of which has been annexed as Annexure 1. It is submitted that invoking the provisions laid down by the Honorable Supreme Court in Priya Indoria, head of citation, so and so, he may be given transit anticipatory bail for transit, no, it's called anticipatory bail to move the jurisdictional court. I've also heard prosecutions. In terms of the law laid down by the Honorable Supreme Court in Priya Indoria Supra, such a power can be exercised to enable the petitioner in a suitable situation to move the jurisdictional court. Stop. I have considered the contentions made by the petitioner and his complaint made before the Rongia police. In the given facts and circumstances, allowing his prayer, is how many days you would prefer?
May I pray for 3 weeks, my lord, at 3 weeks? Because he'll have to go to Delhi, obtain all documents now.
15 days.
But most importantly, the money he'll have to manage, my lord, 3 weeks.
I mean, nowadays, someone from here can help him. Nowadays, things have changed a bit. As
Yes,
I said, it's not so difficult as it used to be.
Yes, yes.
Suppose when we had started. This is possible. Anyways. Accordingly, in exercise of powers under section 482 BNSS, read with the principles laid down in Priya Indoria Supra dash. It is directed that in the event of his arrest in connection with cyber he may be allowed to go on bail of rupees 30,000 with one security to the satisfaction of the arresting authority, and subject to the condition that within the stipulated period as mentioned below, he shall move the jurisdictional court and render cooperation to the investigation from now onwards and in the future. The aforesaid transit anticipatory bail is granted for a period of how many? 15 days? Yes. What do you say? 3 weeks he wants.
3. Yes.
For a period of 3 weeks from today. It could have been better, but anyway.
Yes.
Obliged, great.
Disposed of.
May I please, Your Lordship? This is a 42 application, Lordship. Case is registered at 118 and 35, Lordship. Later, it was added to 103, Lordship. Particular of the FIR is 18, Lordship.
The fighting over return of money, that is one part, but he says that when he asked for the money, his leg was broken.
Maybe,
Name accused was Rafiqul Islam is arrested on the date of occurrence. Other three persons was not present there. So
Who's the petitioner? He's the main accused.
no, Lordship, name accused, there is 4 accused persons in the affair. Rafiqul Islam is arrested immediately, Lordship. And for the 2, 3, and 4. That's
My lord, fracturing of the leg is the first portion of the offense. In the second part, that was my lord compromise. Your lordship may kindly see 37, page 37, last portion, my lord.
Let us read the FIR.
No, that is
People have
from
become
the,
so
but
intolerant,
thereafter
violent.
matter was settled. Then on 2012-25 at 10 AM, accused came to the informant home and took her husband with him to take back his money, but en route accused Asma Begum threw silly powder on informants. So second part is my lord training. And Rafiqul Islam, Asma Begum, Sahara Khatun Islam attacked him with an iron rod.
Oh, later he died also.
yes, Lordship.
Yes,
In hospital. Lordship.
I think only CD would be
yes.
justified in this case. Who are the petitioners?
Asma Khatun.
Asma Khatun, Sahara Khatun, and Rafiqul Islam. Lordship.
See that.
Four name accused in the affair, Lordship. I am for the 2, 3, and 4.
Botagov,
Yes.
what are the allegations against these petitioners?
Yes, my lord. Your lordship may kindly come to page 37, last portion. I will again point out, my lord. 37.
En route, Asma.
Page
chili
37.
powder.
On 2012-25 at 10 AM,
Yes,
accused came to the informant's
Yes.
home after fracturing of the leg, my lord. I promise. The home took her husband with him to take
Renar
back
Hussain.
his money, but en route accused Asma Begum, the present accused Asma
Yes.
Begum,
So,
threw silly powder on informant's husband's eye and accused persons, Rafiqul Islam, Asma Begum, the present accused, Sahara Khatun and Shafiqul Islam, all are accused in the present, and attacked him with an iron rod, causing grievous injury.
let's get the case there. Injury may not be
Yes,
justified at this stage.
Sashvik is an
Heard instance from the Barnet Council for the petition. Call for the case diary of Rupohia, PS case number 425 or 25. And so it's along with medical and PM report.
Yes.
Yeah.
Also. List the matter on
23.
23-4.
Obliged, Lordship.
My pleasure, Lordship. My lord, this is a second bail application, my lord. Earlier, one occasion, my lord, this honorable court was rejected. Page 13 is the FIR, my lord. May I read, my lord?
Case 13.
Page 13.
Yes, yes.
With due respect, I would like to state that on 16/7/25 at about 3 AM, container truck bearing registration number RJ09QE 6232 carrying 396 carton within bracket 99/4 of Mustaba Pan Masala, valued at rupees 84 lakhs 14,753. Was traveling from Guwahati to Siliguri, MS Dharapara Satyapal Ltd, Guwahati, to MS SLRL Agencies Private Limited, Siliguri. While the truck reached Madhapur under Burma Police Station, some unidentified miscreants intercepted the vehicle from behind using another truck. Immediately, a black four-wheeler arrived and 4 or 5 miscreants got down and threatened the driver, who is the present petitioner, my lord, with rods and other weapons. The covered his face with clothes, tied his hands and legs with rope and took away the truck. Later, the driver was left near Bhawanipur police outpost. The driver then informed the police outpost about the incident. This line is important for me, my lord.
driver is the present petitioner initially, who himself informed to the police about the occurrence, my lord. Fortunately, the driver's mobile phone was left inside the stolen truck. Through phone tracking PTL, Bajali police trace out the location of truck at Balapara in the Borpeta district and inform the Burma police. The Burma police then recovered the truck and kept it in their custody. This is basically allegation, my lord, narrated in the FIR. Now, driver, who is the present petitioner himself involved to the initially informed to the police about the occurrence, then why he is implicated? That is stated in the page 59, charge sheet at para 25, my lord. Page 59.
Investigation is not completed.
No, sir, charge sheet submitted.
Charge sheet submitted,
Page
now
20.
trial already started and next date is fixed on 28th April.
Before
Uh,
filing charge sheet, my lord, his anticipatory bail was
Yes.
rejected. Thereafter also, trial court has issued summons, my lord, fixed date for appearance. He has
My
not
lord,
appeared before the
Let
trial court, my lord.
let me complete my submission, my lord. In page 59, para 25. This is the charge sheet, part of the charge sheet,
Yes, I'm on that only.
my lord.
He's a newly inducted member.
Yes, my lord. Now, my lord, I'm humbly submitting before this honorable court.
Azimuddin Barek gang, what is this? Anyway,
Here also is stated that initially I was granted interim PRS bail by this honorable court, and after that I have appeared before the investigating authority and duly cooperated with the investigation. Then CD was called for, and after perusing CD, my lord, my anticipatory bail was rejected. Now at this stage, I am humbly submitting before this honorable court, my lord. Since charge sheet is already submitted, trial commence, my lord. At this stage, there is no chances tampering or hampering with the evidences or witnesses. And my lord, further, nothing to recover from the possession of the present petitioner, my lord. So, my lord, I am ready to appear before the trial court on next date fixed on 28th of April, my lord, within this month, my lord. So, my lord, any condition, my lord, I may be allowed to appear and, my lord, ready to face the trial, my lord. Otherwise, at that time, charge sheet was not submitted while my PRS bill was rejected by this honorable court. Now, charge sheet is, my lord, already submitted. So, I am humbly praying before this honorable court. And any condition, I am ready to appear, my lord.
organized activity. Anyway. Some people were granted bail, I think, after
Yes,
the
Some
completion
people
of
were
charge sheet.
granted bail, yes.
If I remember correctly.
Yes, yes, well, that,
Except T. Oler
No.
bail, my lord.
Except 3 minutes, this one.
This one, this is one petitioner.
Another one.
Yes,
Except 3 persons.
Yeah, yes, yes. Except 3, all accused persons
at
are.
that point of time, my lord, immediately after filing, before filing charge sheet, my lord, some of the cases rejected, thereafter after filing.
So, the allegations are serious, but I go this. Heard Mr. A.K. Azab, learned counsel, and additional people, he brought up. Probably para 72. Sorry, the page 72, para 2 and 3. 2 and 3. The learned counsel fairly submits that
Next date on 28th.
earlier bail petition on his behalf was rejected last on 19/9/2025 bill AB 19778. Though initially he was granted interim bail, but on the basis of after perusing of case diary, the same was vacated, rejecting his bail petition. Full stop. It is submitted that in the meantime, the investigations stood completed in the case, resulting in the charge sheet being CS number 65 of 2025, dated. I can't make out the date 2010/2025. I mean 2010/2025. The learned counsel has also drawn attention of the court fairly to the narration in point number 25 with regard to the present petition. Full stop. It is stated therein about his involvement in the alleged offences of dacoity on the trucks. Full stop. It appears that after completion of investigation, the case is, cognizance has been taken and it is at the stage of appearance, full stop. It is also submitted that, except 3 accused persons, including the present petitioner, the other accused persons are presently on bail. Relevant copies, copies of the relevant documents such as charge sheet, etc., have been annexed with the petition. In view of the completion of investigation and stage of the case and the undertaking on behalf of the petitioner that he is willing to participate in the trial, I deem it fit to allow this subsequent bail petition. Accordingly, it is directed that in the event of service, 50,000 with 1 security, subject to the satisfaction, subject to the conditions that he shall not abscond, shall appear, he'll be available before the, he shall appear before the learned court below as and when required. Number 3, shall be available for trial if one commences. He shall not hamper or tamper, shall not commit any illegal activities. Full stop. Next point. The petitioner is at liberty to submit fresh bail bonds before the learned court below, whereupon necessary orders shall be passed. Violation to listen, violation until cancellation.
Next date is fixed on 28/4/26.
Okay, no problem.
Yes.
Bail petition stands approved. Okay.
I'm obliged.
May I please, your lordship, herein it is a 482 application, your lordship. After receipt of summon, your lordship, I have taken steps, remain absent with steps, your lordship. Your lordship, as I was outside the state in Goa, your lordship. Now I am ready to appear and face the trial, your lordship. In the meantime, no coercive action should be taken, your lordship. A similar order has been passed by the coordinate bench, and except 4 page 26, your lordship. The FIR is of 22, your lordship. Your lordship may kindly see page 13 in the order of the coordinate bench.
The page 13 is the FIR.
Page
Signature
13 is the FIR.
Have it.
Page 13 is the FIR. Allegation is that
Yes.
I was having a love affairs with the so and so, your lordship, in 2022, after 2 years, 7 months, and his family used to visit their house and marriage was settled. Later on, the accused, number 1, that is the present petitioner in connection with the other, used to come to their house on the pretext of roaming and so and remain in a hotel for 5-6 days and establish physical relations. And at present, the accused number 1 is working at Goa. So after filing of the charge sheet, your lordship, and receipt of summon, I took steps. I remain absent with steps, your lordship. And now I am ready. I am at Silchar now. I am ready to face the trial, your lordship. I will appear within 10 days. Till then, no coercive action is in your lordship. Bailable warrant of arrest has also been issued.
What about there is an allegation about uploading?
Yes,
of
uploading
your- have these been taken down or something?
Yes, yeah.
That is my only concern at this moment.
Yes.
The only thing I am ready, I will appear before the.
No, that's okay. That's fine.
Yes,
It's appreciated. You can.
Your lordship kindly.
Because there's an allegation about viraling of photographs.
Yes,
of the
charge
car.
sheet is page 20.
Have they been taken
Charge
down? Hopefully.
Charge sheet is page 20.
Scan copy may be called.
By whom it has been, there are other co-accused. Nothing. Charge sheet, remark column, the prosecution story so and so. All accused either Hiron Raja Loskar, that is the petitioner, either lover and they left Silchar and living in hospital. The accused was raped by a hotel and some naked photos shoot mobile for lover and the accused viral.
That is the problematic part actually. PNA has been issued or not PNA?
No, bailable warrant of arrest. In the charge sheet, I have been declared an absconder.
Bailable warrant is actually not a problem. What are the provisions? Are they sessions tribal?
Lordship.
The provisions are sessions tribal or what?
Yes,
What are the provisions?
Stephen's tribal.
Otherwise, bailable warrant you can appear and get.
Yes, madam, there is no difficulty, only bailable warrant of arrest issued. madam.
Bailable
I
warrant.
will appear, your lordship. Till then, no coercive action.
Only bailable warrant is issued. What are the provisions of charge sheet? Kindly check.
120B, 354, 376, read with section 34 of the
Three
Act.
76.
Page 22, my lord.
Cognizance order.
Let him appear, but the thing is that let us get some scanned documents.
Yes. can
Because
copy-
regarding this
Yes.
viraling part,
Yes, yes.
that's the
violent.
problem. That is the only worrisome thing.
Or it can be disposed of with that direction, your lord.
No, let us get some materials. The case diary will indicate, right?
Otherwise,
Usually they are taken down.
Yes, my lord. Otherwise, my lord,
Usually they are
only,
taken down.
yes, yes. Otherwise, only BA, my lord, available warrant of arrest issued without appearing before the trial court filing appropriate application. Because they, my lord, directly approaching before this.
No, I have appeared before the tribal, I have taken
Has been
steps.
issued only.
Yes.
Now I am apprehending.
Absconder, my lord, anticipatory bail in all.
A bailable warrant has been issued only.
Yes.
Against him. So there is no prospect of arrest.
Yes.
No,
There is
immediate
no
perhaps
apprehension.
NBW has been issued, your lordship. There is the last order. So I appear, your
Last order
lordship.
is 12/10.
Till then,
11.
no possible.
In the meantime, NBW has been issued.
Perhaps. Most likely, your lordship.
You should have annexed that then.
Yes,
BW is
before.
heard so and so. The petitioner invoking 482 BNS is seeking anticipatory bail in connection with PRC number 567 of 23 under section so and so. Arising out of Silchar PS case number 1082 of 22. Full stop. Which is stated to be pending at the stage of appearance before learned SDG and S. Atal Silchar. Full stop. As per order dated so and so 24/10/2025, a copy of which has been annexed with the bail petition. BWA has been issued against the accused. Full stop. The charge sheet has been submitted against the petitioners, against 4 accused persons, against 5 accused
Five
persons, under section 120B, 354, 376, 34 IPC. The allegation by the informant slash victim woman was about love affair with the present petitioner, but subsequently she was subjected to rape, and even some private photographs were alleged to have been made viral. Since the petitioner has expressed his willingness to appear before the learned court below, therefore, this court is inclined to facilitate the same by granting some interim bail. However, to check the aspect of the allegation regarding viraling of photographs, some more materials need to be perused. Accordingly, call for scan case record of PRC number comprising case diary, comprising the case diary.
Yes.
His charge sheet is already annexed, so it's not necessary. Comprising the case diary. However, in the interim, allowed to go on bail in the event of 30,000 to 10, subject to the condition that he shall appear before the learned court bill on next and subsequent dates. Shall not hamper out evidence, shall not harm, disturb, or annoy the informant in any manner. Violation will be control. He is at liberty to submit fresh bail bonds, whereupon necessary orders will be passed. Please, the matter you can give it in.
On my lord, 11th of May. 11th.
Till then, no coercive action, your lordship.
No, it's interim.
Much of it.
May I please, your lord. It's in second time petition, my lord.
Lordship's order, my lord, page 12.
Okay.
Paragraph 7, my lord.
103 case.
Paragraph 7, my lord. So my humble submission, my lord. Up to date diary along with report may kindly recall for me.
Okay.
Lost.
Here. R. Ali, counsel for the petitioner. It's fairly submitted that an earlier bail petition was rejected on 17/12/25 in AB 2808 of 2025. Call for the, it may have been completed also, maybe.
Lordship.
Call for the up-to-date case there. Along with medical report.
That's FSL report.
Along with medical and FSL report
Right.
from the concerned police station. List the matter on.
On 27th of April,
Little earlier.
23rd.
Okay.
Lost. Okay.
May I please, Your Lordship? Actually, 482 application, Lordship. Allegation is under section 3032, that is theft of vehicle. FIR in Lordship, page number 12. Lordship, the gist of the FIR is that the vehicle of the informant was parked in certain place, and in the morning he has seen that his vehicle has been stolen by somebody else. Now, Lordship, kindly turn to page number 16, that is the inquiry report, Lordship. Page number 16.
Okay.
Where it has stated that, Lordship, after filing the FIR, may I read, Lordship? It is very small. I have the honor to report that as per your kind endorsement, I have made an inquiry on the complaint lodged by one Rafiqul Islam of so and so. During inquiry, it is learned that the stolen vehicle and involved person were intercepted in Dhalai PS Karbi Anglong during Naka checking. As discussion with supervising officer, it is necessary to recover the stolen vehicle and apprehended the involved person for proper investigation and found sufficient ground and reason to register case. But since the vehicle has already been recovered along with the involved persons. Now, in this case, Lordship, the co-accused has already been allowed to interim by your Lordship. It's order.
My lord, from the inquiry report, it is not well reflected that the present petitioner is not at all involved. Because after my lord commission of the theft, my lord, those vehicle, my lord, that vehicle was recovered in a place at Karbi Anglong during Naka checking. That was already after intimation
Yes,
received from the concerned police station, my lord.
yes, Lordship.
Otherwise, there is specific allegation against the present petitioner.
No.
This
No,
person
my
was
lord.
a stated to be a neighbor.
No.
Yes.
A friend of the petitioner.
Yes, Lordship.
And therefore he was called, and accordingly it was he was granted interim.
Yes.
But as,
Here
as,
in this case,
as the prosecutor has said rightly, we do not know anything else
Yes,
regarding
yes,
this.
ready
It
to
is not a
appeal.
regular bill. We have the benefit of the forwarding.
Yes, ma'am.
It's fixed on. This is what is the? It's disposed of this one.
No, this one fixed on 5/5, Lordship. So I'm ready to appear, Lordship. The vehicle has already been recovered.
Vehicle
this thing,
recovered, but
and
my lord-
already allowed to in Jimma. That involved person already intercepted and arrested already, Lordship.
He was arrested.
No, the present petitioner
No,
was
no.
not arrested. The involved person
Yes.
already been in Dhalai PS. The vehicle as well as the involved person has been arrested as per the inquiry report, Lordship.
Sure.
Just that arrested Akhirul Islam is my friend.
Hello, only
Police is after me,
schedule,
Lordship.
only schedule reveal, my lord, regarding how he is involved, my lord. Otherwise, matter relates to vehicle theft, my lord.
Otherwise, if we can grant interim, but you fix it in the first this week.
Yes, yes,
That it come.
yes.
That,
Your lordship may fix it on 23rd or 22nd.
My request has already been.
Well, that's true, but again,
same
it has to
footing.
be held back and then seen again with regard to the other person.
Yes,
Other person,
yes.
it is fixed on 5th.
Fifth.
So we fix it on same day or a little earlier.
Well,
Then-
without
Then
protecting,
retain the case there
because,
no, if it's no, with protection.
no, my lord, I can get it on 22nd, man, without putting in on 21 or 20,
Since
because
it is fixed already.
regarding
5/5,
vehicle
another
theft, man,
application. Lordship,
on
for
that case, in that case, my lord, on what ground?
I got to call it, huh? Heard, so it's full stop. Petitioner. And 2, 3.
Interim also. Interim to assign.
Except for the next paragraph, except for the fact that the stolen vehicle was stated to have been parked on the previous night before the shop of one Abdul Hanif Sheikh. Nobody else is named in the FIR. Full stop. As per the inquiry report, which is annexed as Annexer 2, during NACA checking, the stolen vehicle and involved person were found are stated to have been intercepted at Dhilai PS Karbi Anglong. Full stop. The Learned Council submitting a copy of order dated 8/1/2026, passed in AB 51 of 2026, has submitted that another person, Sohidul Islam, was also not named in the affair, and he was a friend of the informant, has been granted interim bail, interim prior's bail, and the matter fixed on 5th May. Full stop. The present petitioner is also a friend of the petitioner, or of the informant.
Yes, yes.
He is also a friend.
They're the
The
friends.
petitioner, present petitioner is also stated to be one such friend.
Location number given us. Location number.
No, not it for.
51 of it.
Call for the case diary of so and so police station. However, in the entry, para 6 to 10. 30,000. 30,000. 30,000. 30,000. Consider it. Okay. Then what do you do? Fix it on same day?
Yes, yes.
Okay, 5/5.
Yes. List along with 5126.
Along with
AB number 51/26. Hello.
break. Fact. 5th May.
68.
It was a break it long, yeah. Not all.
Already 4 accused are released by bail bond by IOL. Page 18, Lordship. Page 13, Lordship. FIR is there. The informant and petitioner are husband and wife, Lordship.
Husband?
I just did. The informant begged to state that for the long time she fall love and affection with the accused, number 1, and finally turned into physical relationship on the pretext of marriage, for which she was pregnant. It is further alleged that after 2 months of her pregnancy, it was terminated by administering medicine. Subsequently, on date 26, 2025, during her pregnancy period, they solemnized a marriage at Silchar Court by executing court affidavit marriage, and also performed ritual in a temple. Therefore, the accused left her at her parental house. Thereafter, the illicit advice of other co-accused, the accused number 1 settled his marriage with another person. After knowing the fact, she tried to communicate with the accused, but he threatened her. That there are no way to disclose full fact to accused number 2, 3, 4, and 5 for solution, but no result. Then the informant is bound to file this FIR. Lordship, kindly see in affidavit in Lordship. 16 and relevant page is 18, Lordship. Page 18, Lordship, kindly. Para 6, Lordship, it is clearly written that we have been in love with each other since long, and due to our such love and affection for one another, we had decided to tie the knot of wedlock, and thereby we solemnize our marriage as per Hindu riti and rituals on 30/5/2025. But FIR is filed in 2/2/26. At local Shiv Mandir at Airangmara, district Kasa. And para 9 also it is clearly written that we jointly as well as severally state that we shall both be loyal and faithful
that's okay.
towards one another.
The problem
and
is
shall
when
live
he
together.
married another person. He settled his marriage.
It is lordship no, the petitioner has no any condition. His father and his brother, sister and they also try to, but she is not deny. She denied in para 4 lordship. In my petition in 4 lordship, he denied it lordship clearly.
What is denied? Informant is doing both studies, he does not.
He said, but it is false that again he marries being settled to another place
Then there's
for
no
his
problem. They can-
family member.
They can go ahead with the marriage if the relationship is okay. Anyway,
So they are husband and wife lordship. And due to a uneducated, unemployed person, that's why it is difficult for him without the decision to take him in home against her fathers.
third, learned edition, 482 bail application. Duarbon PS case number 7 of 26. The petitioner stated to be aged about 21 years, seeking anticipatory bail in connection with the FIR lodged by the alleged victim girl of same age on 17/2, what is the date? The FIR?
22-26.
20th February 2026. The gist of the allegation is that she was having a relationship with him, followed by, she was having a love affair with him, followed by physical relationship, resulting in her pregnancy, which was terminated with medicines. Subsequently, they solemnized their marriage by executing an affidavit and performing rituals in a temple. And thereafter, it is alleged that he is, with the advice of the other accused persons named in the FIR, he tried to settle his marriage with another girl. Full stop. The Learned Counsel has drawn attention of this court to the copy of the affidavit made between the informant and the present petitioner. Full stop. It is also pointed out that in para 4, the para 4 of the petition supported by affidavit, the petitioner has specifically denied that he has settled his marriage with another girl. Full stop. Call for the case diary in the circumstances, 25,000 at 170. Satisfaction of state authorities. Cooperate in the investigation, shall not intimidate, harass, or harm the informed in any manner. List on
13th of May.
13th.
Intimate allowed.
With interviews. He'll appear. He can record his statement.
And also, lordship, his statement may be recorded.
Yes,
in
I have given.
Yes.
Yes, Mr.
The lordship, there's a 482 application, lordship. The FIR is a page 11, lordship. Lordship, I'm sorry, only on the first line, date has been wrongly mentioned. It should have been 28/3/26.
28/3.
23. Lordship, may go to the vernacular portion. Lordship is a political library case lodged from the ruling party against the opposition, lordship. That's election.
Which one
time
should we read? 11 or 14?
Lordship, go to the vernacular part also, lordship. Page 13.
Go ahead.
সন্মান সহকাৰে আপোনাক অৱগত কৰিব বিচাৰো যে আজি 28/3/26 তাৰিখে শনিবাৰে দিনৰ 9 বজাত মই মোৰ সতীৰ্থৰ ক্ৰমে প্ৰিন্স শইকীয়া, ঋষিকেশ বৰা, উৎপল কটকী, জ্ঞান নাথ সহ জামুগুৰি ভাৰতীয় জনতা পাৰ্টীৰ নিৰ্বাচনী কাৰ্যালয়ৰ পৰা টুকিয়াস্থিত নিৰ্বাচনী কাৰ্যালয়লৈ গৈ থকা অৱস্থাত আমাৰ বলেৰো গাড়ীখন প্ৰাণেশ্বৰ বসুমতাৰীৰ নেতৃত্বত অহা গুণ্ডা বাহিনীৰ দলটোৱে তেওঁলোকৰ 6-7জন গাড়ীৰে আগচি ধৰি আৰু আমাৰ ওপৰত অতৰ্কিত আক্ৰমণ কৰে। হাতত চকা অস্ত্ৰ লৈ আমাক আক্ৰমণ কৰা 24-25 জনীয়া দলটোৰ নেতৃত্বত থকা প্ৰাণেশ্বৰ বসুমতাৰীয়ে পিন্ধি থকা নীলা ৰঙৰ জেকেটৰ ভিতৰৰ পৰা পুখুৰী ওলাই লয় আৰু সতীৰ্থ প্ৰিন্স শইকীয়া দৌৰাই নি মাটিত পেলাই গৰুলাত মৰাৰ উপৰিও পুখুৰীৰে প্ৰাণেশ্বৰ বসুমতাৰীয়ে আক্ৰমণ কৰি তেজেৰে ৰঙালী কৰে আৰু হত্যাৰ চেষ্টা কৰে। এই ঘটনাত উৎপল কটকী, ঋষিকেশ বৰা সহ আঘাতপ্ৰাপ্ত হয়। গতিকে Now, Lordship mentioned this Praneshwar person is the ex-MLA. His vehicle has been damaged, Lordship. I have the pictures at page 21, Lordship.
That is his vehicle. That
Lordship.
this is his vehicle.
His vehicle, Lordship.
Anyway.
Lordship, here, Lordship is the ex-MLA, then one is the block Congress president, then another is the ex-DP member, others are worker, Lordship. So, listen, political rivalry dispute, Lordship. Lordship will call for the city, but interim, let us protect that at least we may participate in the electoral process and we exercise our right to vote, Lordship. Lordship will call for the city. We have also lodged an FIR, Lordship. That will, Lordship will find from page 22 honors.
22.
22. We have submitted before the superintendent of police and also the election observer, all, Lordship. Copy has been served to the DGP also because we can't go to the police station, Lordship. But our is yet to be raised. I don't know whether by this time it has been registered or not. So, Lordship will come for the CD in the meantime, Lordship. Let us exercise our democratic right, Lordship. Though it may not be fundamental by the statutory right, Lordship.
Heard B. Chakraborty, Learned Counsel, and P. Butterfield. Invoking 482 BNSS, the petitioners herein, the 10 petitioners here.
10 petitioners,
seeking
Lordship.
anticipatory bail in connection with Jamuguri PS case number 27 of 2026. Under section, the case arose out of an FIR. This informant is Praneshwar Bosumtari.
Praneshwar is petitioner number 7.
Vivek Paul, I'm sorry.
Deepak Gora is
Here petitioner is, informant is Vivek.
One Vivek Paul.
He's also named in the FIR.
With the allegation that on 24/3/2024, while he and his companions were returning from the election office of one political party in connection with the elections, they were attacked by a group of miscreants led by the petitioner, accused number 1.
Petitioner number 7, Lord. Otherwise, accused number 1.
Accused number 1, Praneshwar Bosumtari, stated to be an ex-MLA. And they attacked and they tried to assault them. They assaulted them by kicking and beating and attacked with kukri, causing injury. It is submitted that the dispute arose out of some political rivalry, and that the accused number 1 and other companions were traveling in his vehicle, and they were attacked by the other side. Other side, as a result of which his vehicle suffered damage. A photograph of the same has also been annexed. He stated that in connection with the same, he lost an FIR before the Jamuguri police station, but perhaps in the meantime does not have details about his registration. It is submitted by the learned counsel that while case diary may be called for, they may be given some interim protection, failing which in the absence of which they would be handicapped in participating in the elections. It's call for the case diary. In the interim, in the event of arrest, so and so 25,000 each, subject to the condition that they shall cooperate with the investigation. Number 2, they shall not hamper or temper dividends. they shall not indulge in any illegal activities or any activities in breach of peace.
Deeply obliged.
For- for
Date to
14th of May.
14th of May.
After counting lots.
Yes.
Maybe the lordship.
Samaguri PS case.
Lordship, this is an application by section 482 for granting a pre-arrest bail. Lordship, the FIR is at page, from page 10 to 16. Lordship, the translated portion is at page 13, my lord.
13.
Lordship, allegation is that Lordship, the petitioner entered the house and committed rape on the informant.
I see. Kothalguri, no?
The Lordship, the actual fact is that the petitioner and the informant, they were in a relation.
Hmm.
On 14th, it was the petitioner's birthday, they celebrated together. Informant wanted to get married immediately. Petitioner asked for reasonable time to get married, citing his financial condition.
Hmm.
Therefore, some conflict arose between them. Lordship, the families are also aware of the relationship. In fact, the villagers also held the meeting to resolve.
What do you say? The victim's statement is stated to be incriminating, 183.
Yes.
Let me see this.
As per resolution order.
Is there anything, I'm looking for any material to, which lends support to your contentions. Maybe that is your instruction, may be corrected. As per the language in the FIR, it appears to be a sexual assault, but is a
Page 15, he forcefully raped me against my.
no, that is there. That is there.
Yes, FIR is registered after 16 days. That part is there.
That is the only thing. 18 days.
10 days. Otherwise, she implicated.
Heard and counsel for the petitioner and P. Gauhati learned additional PP. The invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Samaguri PS case number 36 of 2025. The allegation in the FIR dated 1/1/2026 is that the petitioner is our neighbor, and on 14 January 2026, he entered her house while she was alone and committed rape upon her. Full stop. Learned counsel submits that the facts have been distorted by the informant, in as much as the petitioner and the informant have been in a love relationship, and with plans to marry. And on 14th, on the day of the alleged incident, they celebrated the birthday of the petitioner, but subsequently some dispute arose with regard to the time when their marriage was to be solemnized. and that in the context of the same, the petitioner was seeking some time to solemnize the marriage. Full stop. It is submitted that the petitioner, the families of the petitioner and the informant are aware of their relationship. It is pointed out that the FIR was lodged after 18 days and that he has been falsely implicated. Full stop. Call for the case diary from the concerned police station. Though an allegation of sexual assault has been made, but it appears from the, there is some delay in the FIR, delay of about 18 days in lodging of the FIR, delay of more than 15 days in lodging of the FIR. And by way of explanation, the informant has stated that she was mentally and physically traumatized after the incident. The contentions regarding the veracity of veracity of their supposed relationship can only become clear after some investigation materials are produced. Therefore, at this stage, perhaps the petitioner can be given an opportunity to record his statement. Call for the case diary, however, in such view of the matter, 30,000 with 1 separate. Number 3 conditions: he shall cooperate, appear to record his statement, shall not in any manner intimidate, harm, or harass the informant in any manner. Violation will entail cancellation. List on first week of
Yes, my lord, on 5th of May.
5th of May.
5th of May.
Deeply obliged.
May I please, Your Lordship? Lordship, the matter is that the allegations are that some public has beaten up one lady suspecting that she is child lifter. The affair is at page 10. Lordship. I am not named in the affair. Says that in Sabkata area, the
This was
incident happened. Lordship.
my mother.
আৰু দুটামান কেছো ফিক্স আছে
number 56 supplementary
আজি আছে কৈ দিয়া
He may be mentally disturbed person.
Yes, earlier also some matters listed,
And Lordship, one matter has been listed today before the Honorable Court of Court number 14, Lordship. In that matter, CD is available. I have come to know, Lordship.
It can be. Should
So
I?
Yes.
That is disposed of.
Yes.
Can be fixed tomorrow before the
Tomorrow, yes, Lordship,
appropriate
with this CD, Lordship, because otherwise CD may be retained, Lordship. And item 56 also connected, Lordship. Today,
But regarding my lord, availability of the CD, my lord, I am not at all aware, my lord, as he has submitted.
I have
So fixed, my lord.
tomorrow. Tomorrow.
tomorrow,
Yes,
Lordship.
day
For the
after
appropriate. The petitioner is seeking anticipatory bail in connection with Gosaigaon PS
Yes,
case
yes.
number 46 or 26.
Lordship.
However, the case diary is stated to be available in connection in regard to a connected bail application before another coordinate bench. Accordingly, leave this matter for the appropriate bench along with
Lordship.
number you have.
That matter may be disposed of also today. So I am
No.
what I am praying, Lordship. This CD may be retained and this matter may be
List before the appropriate bench,
on not 8th, Lordship, on 8th.
not tomorrow.
Not tomorrow, on 8th as well. Tomorrow I have some learned friend of
8th.
on 8th, Lordship.
That BA number is, my lord, 89526, one cases, and another AB
Yes.
is 75426.
Item 56 also supplementary same matter, Lord.
56 council is not there, so.
Yeah.
56 it will, huh? 56 it will.
May it please, Lordship. Lordship, I am on behalf of Mr. Sanu Hussain. This is a non-FIR anticipatory bail.
Non-FIR.
Lordship, today's first date.
What is the,
I will get a report, my lord, regarding whether any case can be.
tomorrow? We don't have time unless interim order is given, then maybe.
Day after tomorrow, my lord, I will try to get it.
After tomorrow, I'm keeping minimum.
Oh, yes,
matters.
yes.
So that.
Then
we can-
immediately after.
No, we can, a few, only so far. On
21.
I think we have not fixed many matters till now. It
Yes,
is
yes.
below 10.
On 20.
4 only, so fix 4. We can fix it on 8.
8,
Huh?
yes.
The petitioner is seeking anticipatory bail in connection with in connection with regard to anticipatory bail invoking 482 BNSS, the petitioners. However, they do not have details of any case registered at Jogigopa police station. Call for a report from the concerned police station as to whether any informant, whether any FIR or case lodged or in case registered. Till the returnable date, the petitioners shall not be subjected to any coercive action. Since we are approaching, day after tomorrow, you're trying?
Yes, sir.
List on 8.4. Much obliged, Lordship.
My lord, free arrest bail application. The petitioners before your lordship are husband and wife, my lord. Two petitioners. Free arrest bail, my lord. Two petitioners before your lordship, husband and wife, my lord. Although the present petitioners had earlier preferred a bail application, my lord, which was rejected by this honorable court, my lord.
No problem.
I have annexed the order also, my lord.
We'll see it again.
In this case, my lord, earlier some documents could not be annexed by the earlier council, my lord, due to miscommunication. So, my lord, now we have annexed some documents. Placed before your lordship. Yes, yes, my lord.
Updated case diary may be called for.
My lord, the gist of the allegation is that, my lord, on 26, the informant recovered his son in injured condition. Later on, my lord, day after the occurrence, he died while undergoing treatment in the medical hospital. After 3 days, my lord, as per the contentions of the FIR, my lord, the informant received information from one third party, my lord, that is Abdul Shahid, who stated that he had seen the present petitioners and others were assaulting the victim, my lord. And on the basis of his statement only, my lord, the FIR has been registered. Now, my lord.
Up to date case diary?
Yes, well, up to date case diary.
We'll see the documents also. Okay.
My lord.
We'll see the documents also.
Yes.
Additional documents.
Oh, my lord, immediately after reopening, my lord.
Microphone. Microphone to audio system to side of
21 on 24
record at 1 o'clock. Okay. Earlier bill petition was rejected on 12/3/2026 in AB 372 of 2026. Learned counsel submits that the whole case was registered based on the statement of only one person who is alleged to have seen the occurrence. It is also submitted that in the subsequent bail petition, they have annexed some additional documents which could not be produced in the earlier bail petition. Nevertheless, call for the updated case diary fixed on
27 formally.
Is it okay for you?
Obliged.
56, we fixed the date, no?
Yes,
Yes,
it fixed well on
19 lordship.
28 form.
With item 19.
No.
Obliged.
Same order. I got to Milosin. Case diary is stated to be the petitioner is seeking anticipatory bail in connection with Gosaigaon PS case number 46 of 26. The case diary is stated to be available in connection with another bail application before a coordinate bench. List the matter before the appropriate bench. The case diary is stated to be available along with the that number, what was that number? What was?
That's before
DA?
another bench, Lordship.
Huh?
Before another bench, Lordship.
That
That
DA number he had given a
895 2026, Lordship. DA, Lordship, that is DA.
DA 895, list on 84.
Lordship, development.
No, 895, that is BA already today listed. That may be disposed of.
Disposed of. So but still it will come.
Yes.
If we give like this, it will come DO as DO.
Here in site number 29, my lord.
Mhm.
Service has been completed.
My lord, here we have received the service report, my lord. As per service complete, my lord.
It is the item number.
29, ma'am.
Seen. Okay. POCSO matter.
POCSO.
Services complete.
Service complete. We have received our report, my lord.
Amicus list.
My lord.
Bora, Land Council. The scanned TCR is already available.
Received, my lord.
Prosecution submits that service upon S1 number 2 is complete. However, as none has appeared, T Parasat 74, I think. Very good. List. These are Land Council. They hereby appointed as amicus to represent the informant. List the matter on. List the matter on. You
My lord,
the,
scan copy already received, my lord.
copies
Oh, my lord,
furnished
on
to
the
the
staff
learned
my lord.
amicus. We can take it up before vacation also.
After
if you
vacation.
Want. If you want. After vacation.
After
You
vacation.
can put, if you can adjust, no problem. That no, date দিয়া নাই না কৰিছিল না তুমি
মই কোথায় কৈছিল মই কোৱা নাই কোথায় কৈছে কি কৰা হ'ব বুলি
finalist date finalist date
মানে after bill মানে
no
as
yeah
as fixed by the rest
on
as fixed by the rest মানে if they have not interested for that
okay list the matter
in the meantime my lord documents my lord
yes list the matter in April after view vacation on a date to be fixed by registry. If it gets late you make a mention.
No clear lordship, the CD was called for lordship.
That's good.
Lordship, the case 20 lordship, the arrest memo lordship.
My lord, I has paid for another debt, my lord.
The lordship, the case 20 lordship, the section 36 not follow lordship. The interim bail lordship may be granted lordship.
Otherwise, what is the allegation of rape?
Section 351, 2, 54, 1, 75, rape lordship. 75. FRP 10.
Labor.
Well, SCD not received, my lord, we'll have to verify my lord regarding the whether
anyway.
it's complied or not, my lord.
No, it's okay.
The interim bill may be granted lordship.
Allegations are.
The earlier date also the same lordship, the report lordship.
We can take one chance on
My lord.
where on Wednesday on 8th or after vacation. Reopening, my lord.
Reopening, my lord. Will telephone ke my lord take statement.
He's in custody.
Immediately, my lord.
He's in custody since. So that is also important.
21st February, Lord. Today's 46 days.
Reopening, my lord. Just reopening, my lord. 21st, my lord.
The case diary has called for is not yet received.
21st.
IO is seeking another date. The petitioner was arrested on 21/2/2026. 21/4.
এখন আগতে নেকি কৈছে? 21st, my lord.
21st.
My lord.
The regular bail application is arrested on 14th.
31.
And reason that he is in
31.
custody for 51 days, my lord. 60 days mandatory period, my lord.
Diary has come.
He has received.
My lord, 108 B, my lord. Lordship will find the FIR at page 17, which is a vernacular.
As per the forwarding report, there was blackmailing with regard
My
to
lord, that is the allegation.
photographs.
But the informant, he is the husband, my lord. He did not raise such a allegation.
Well, he
Anyway,
did
my
not
lord-
know, he said at that
Well-
time. Anyways, he did not know.
51 days in custody, my lord.
Let him see the diary.
Investigation might have been progressed well, my lord, in the meantime. 60 days, my lord, mandatory period. On this, Lordship will consider the length of detention. The FIR that the husband did not allege.
Anyway,
Well, this is the statement of the husband, my lord. PM report not yet received, my lord.
any electronic evidence seized?
Regarding, yes, my lord, those are, my lord.
PM report not received. Then how about sending it back?
Regarding report regarding that, my lord, electronic evidence also not yet received.
No, without pay, because he is alleged that he cannot
Yes, yes.
say
Yes,
whether it is homicide or suicide. I think
that is not yet.
PM report will be necessary. I think.
PM report.
So keeping it pending, can we send it back and get it?
Yes.
Lordship will see that at this stage, the 108, my lord, 60 days mandatory period, my lord. Now 51 days in custody.
About, I think otherwise it is slightly difficult, sir.
Yes.
Because because there's some these social media things. Because they have made some this thing that to recover those videos, his examination is necessary. They say, the IO says, and also to there were some monetary transactions also. They say, let me see this.
So, a husband stated that prior to the day of the incident, my lord, she provided an amount of rupees 30,000 to the accused man. She paid an amount of rupees 30,000. That is statement of the husband. He knows that there is a relation between the accused and the deceased man. But
It is nothing. After the.
no gandagol mein press.
Yes, very much. It's very implicating, no? Hurt. invoking 483, the petitioner seeking regular bail, B Puria PS case number. He was arrested on 14/2/2026. The allegation in the FIR is that he received a video. He received a photo on his WhatsApp. The informant received a photo on his WhatsApp about his wife hanging in his house. And immediately he contacted his family. And he alleged that the death of his wife was due to instigation by the present petitioner. Full stop. They also have a child, aged about 7 years, it seems. It seems now, it appears, aged about 7 years, full stop. In the ground of arrest, the IO has mentioned that during the initial investigation, it came to light that the petitioner had procured some private videos from the deceased and had been threatening her with that and extorted money from him. And the same was also sent to her husband. It is contended by the IO that to recover these videos and to ascertain the financial transaction, the examination of the victim of the examination of the petitioner is necessary. The case diary has been received. The learned additional PP has pointed out the statement of the informant. I peruse the same and find that it lends support to the allegations, including the narration in the forwarding report. Full stop. Yes, he has stated that repeatedly the petitioner was pressurizing and threatening and blackmailing his wife with regard to such videos and extorted money, and that these were also sent to him. Full stop. Learned petitioner counsel has stated about the length of detention. Nevertheless, considering the serious nature of the materials that have emerged and the contentions of the IO and the fact that investigation is not yet completed, it would be wise to reject the bail at this stage. So accordingly, bail petition stands rejected at this stage. Return back the case to later on, we'll see. Let's go.
Mr. Lordship.
Yeah.
Lordship, the petitioner is behind the bar since it's been 92 days as of today. And the allegation is that 85,000 of fake currency note have been allegedly recovered from me. Already charged sheeted matter, Lordship.
Trial is going on, right? Trial is going on.
Yes, trial is going on.
Charges have been framed. Trial has not started, probably. The evidence has
My lord, not yet. Evidence is there, my lord, but no PW examined, my lord.
no PW examined.
Charge has been framed.
Charge frame on 17th March, my lord, 2026, my lord.
Can be allowed at this stage?
Yes.
Since when he is in
This is
study?
312026.
My lord,
Co-accused already been released on bail, Lordship.
it was recovered from his conscious position, my lord. My lord. 85 numbers of fake Indian currency, my lord. From the FSL report also, it reveals that all are the fake Indian currency, my lord. And from the statement also, it reveals that, my lord, they have taken 2 lakhs original and gave 5 lakhs
Fake currency.
fake currency, my lord. They are
Ending.
involved in doing this business, my lord, for a long time, my lord. And till today, only last order 31/3/26, no witness examined. And next that is, my lord, 24.
24/4.
My lord, 20/4/26, my lord, for evidence, my lord.
Okay. From whose custody around 30,000 of fake currency notes have been recovered, already been released on bail by the learned trial court.
Who are the other persons named?
Jakaria Mandal, and I am here Ashadul Mandal.
Do you have a copy of that order? He was released by learned court below or this court?
The learned court below.
Court below, my
The
lord.
copy of the order is there in the scan copy. Lordship.
Is there? I'll see.
My lord, parity may not be considered in each and every case, my lord.
That's true. This is all
My lord.
situation specific.
My
fact specific. It was also found from him, that's true.
Lordship, I am a resident of the permanent resident residing in Assam itself, within the jurisdiction of this court.
Elbonic Land Council and B. Sharma. Additional people. Post. Invoking 483 BNSS, the petitioner is seeking regular bail in connection with Bongaigaon PS case number 1 of 26. Within bracket PRC 68 of 26, which after completion of investigation has been registered into sessions case number 20 of 2026 and poised for prosecution evidence with next date fixed on 24th April. 20th April.
20th.
The scan record has been received, full stop. The present petitioner was arrested on 3/1/2026. The allegations were about dealing with fake INC, I think fake FICR, fake Indian currency. Fake Indian FICR. Here, the copy of the charge sheet has been annexed with the petition. Ms. Banik Learned Council submits that co-accused Jakaria Mandal, from whom also the contraband in the nature of fake currency was seized, was granted bail by the Learned Court bill. Appears the said order available in the TCR. Prosecution opposing the bail at this stage submits that there was recovery of fake FICR from this petitioner as well. And that the aspect of parity would not come automatically. I've perused the materials and considered the submissions. Full stop. Stop the considering the length of detention, the fact that the case is poised for commencement of trial, and the fact that co-accused from whom also there is recovery, dash have been dash to that now. Recovery, have been granted bail. Dash. I'm also considered that this matter can this petitioner can also be granted bail subject to suitable conditions. Accordingly, it will snap 50,000 with 1 service. The satisfaction of Learned Session Judge Bongaigaon, subject to the conditions, will not abscond, shall be available for trial. Number 3, he shall not hamper or tamper with evidence. He shall not commit any illegal activities or offences, allowed and disposed of.
May I please, Your Lordship? Regular bail application, my lord, offence under section 6 of POCSO Act and section 345 of Immoral Traffic Act. My lord, FIR on page number 18, my lord.
My lord,
So notice is complete.
before starting my colleague, my lord,
Notice is
here
complete.
office note is there, my lord. As
Just-
per office note, my lord, scan copy,
Just a minute.
Receipt.
scan copy is it? But not in the, it was shown in the cause list, my lord. And another thing is that, my lord, regarding the service of notice, my lord.
Yeah, scan copy is received, but so what I was just asking that. So
My lord.
what about service?
But in the cause list, it was not shown, my lord.
Okay, this is
Mine.
received. Service of notice. Since it's
My lord,
POCSO.
informant is police officer, my lord.
Acha, police officer.
Yes, my lord. Total 3 numbers of accused persons are there, my lord.
Oh.
And accused number 3, Zuridas, is before this honorable court.
My lord, here, Kushal Daka informant, my lord, as I buy
All
him,
taken.
he is by name, my lord, that's why sometimes.
Mhm.
My lord, it is by name, my lord. Informant is by name.
By name.
By name.
I've
That's why
seen.
sometimes they also appear by engaging advocate, my lord.
It is unlikely to, but you can take an instruction.
My lord.
You can take an instruction.
My lord.
Second half, you can take an instruction.
Obliged, my lord.
And
Or if you face inconvenience, then tomorrow.
my lord. We'll have to again go through record also.
No, no.
It was not shown in the cause list.
Okay. Then tomorrow?
My lord.
Tomorrow.
Tomorrow.
Obliged, my lord.
Another case I think we fixed today, some other date after vacation. But anyway, I'm not saying that we'll have to fix this. But
No.
okay, we call for the scan record, I think. And I think this is already available. I think because who called the area and the same case appears to be
Minor.
immoral traffic. Same appears to be.
Kuntu? My lord, in which item, my lord?
I don't remember the name
Today's my lord?
today.
Belit ke session nikalna.
No.
We may not have called the, because scan copy calling again duplication.
My lord.
Because they don't have time.
My lord.
So
Tomorrow.
anyway, so,
Obliged.
yeah. It will go to next tomorrow.
Item number, item 34.
Yes.
It was called for last time. My lord, here's charge sheet submitted. my lord.
Charge sheet submit.
My lord. First, kindly with the direction to the planet code business.
Copper and he's a scrap dealer.
My lord. Bihar is a old person. His age was 60 above, and today is 31 days, 32 days behind the bar.
Your good name
In Islam.
and Islam Learned Council and D. Sharma. Full stop. The petitioner was arrested on 5/3/2026 in connection with dispute PS case number 122 of 2026 in the so and so section. Full stop. The gist of the allegations about theft of some property in the nature of copperware, brass materials, etc. The present petitioner is stated to be a scrap dealer, and he was arrested during the investigation. Full stop. Upon calling for the case diary, the learned APP submits that in the meantime, investigation stood completed and has resulted in a charge sheet by
Charge sheet number 11126 dated 31/03/26.
the petitioner was arrested on 5/3/2026. In view of the completion of investigation, allowed to go on with 50,000 with one security, subject to the condition that they are available for trial if one commences. Number two, shall not hamper or temper, shall not indulge in any illegal activities or offences, violation. Hello. 50,000, 10.
So that case from Thursday, my lord, case diary was not there, my lord. Lost cases, my lord. Today, perhaps the case diary has come, my lord. Your lordship will kindly come to page 14 first. Item number. Give the brief background of item number. 58.
58, my lord.
769.
That's how I have got the series after, my lord, at 2, my lord. At 2, my lord.
Okay. Anyway,
I will have to go through this.
it will be only part hard time after 2.
Come deep to your place.
I couldn't find. Yes.
The state copy was called for, my lord. Petitioner, my lord, in judicial custody since 10/3, my lord. And a charge sheet has already been filed, my lord. Trial is about to begin, my lord.
FIR is on 2017.
17, my lord. Here in the charge sheet, my lord, he was shown as the absconder in the charge sheet, my lord. And
Then-
thereafter, my lord, 3/11/17, my lord,
He was,
warrant of arrest issued against him, my lord.
and then he was it.
Thereafter, my lord, report received on 19/12/22, my lord, he was declared as proclaimed, my lord.
Proclaim abscond.
Proclamation issued
I see.
on 19/12/2022.
orders then.
My lord, yeah, I have flagged my lord, their orders, my lord. And 10/3/2026, he has produced on the strength of PNA, my lord. During the long period, my lord, he is evading arrest, my lord, absconding, my lord. Now see, I have flagged my lord here.
Absolutely.
3/11/17, my lord, first order.
What is his name?
His name is my lord
Abdul
Abdul
Jalil.
Jalil, my lord.
Abdul Jalil. Others have appeared. The trial has got delayed between.
And lordship, may kindly praise the injury report, my lord. I have flagged my lord, injury report, my lord. 1, 2, 3, 4, 5 people injured, my lord. Series one to series is there, my lord. I have flagged 5 injuries are there, injured person. Some grievous sharp weapon is also there, my lord. Simple blunt.
Injury.
Simple sharp death is also 5 injury.
Simple is the.
No, simple. Grievous sharp was Silimuddin.
Grievous. Some injuries are simple, some are grievous.
My lord.
Grievous injury,
Sharp
blunt
weapon.
object.
Sharp weapon also.
Khairul Islam.
In fact, my lord, petitioner was not there, my lord, and he, during this long period, my lord, he did not receive any summon, no, any information has been given to him, my lord, about the.
Was he searched in his house? Because the police
My lord.
usually has notice.
My lord.
that-
Some search there, my lord.
Anyway, according to him, he was not absconding.
No absconding, my lord. He
Must have been absconding.
he having a small shop in the village, my lord, and he is always attending there.
Anyway,
For a long time, he is evading arrest, my lord.
Yes,
And
my lord.
after
Let
I'll have
me-
to see this.
my lord.
Let me face the trial, my lord.
That's okay. That's okay.
And from the witnesses also, his implication is there, my lord, against him also.
Anyway, we'll close the argument.
My
We'll close the argument.
lord.
Dictate in chair
My lord.
later on.
Madam, I'm sorry, madam, one matter, I'm sorry to mention
No.
on the next item, item 60, madam.
Yeah,
Can it be taken tomorrow, my lord?
tomorrow.
Tomorrow, my lord.
CD to 9?
9. Today was the 90th day, so tomorrow will be 91st, my lord.
Okay. Is
CD,
it? CD is not come
No.
tomorrow.
Much of them.
Admission matters, any mention? Thirty-five.
35.
AB decent. AB decent. CD was not received today also. Oh. The case diary is not received. Issue reminder for the same also. By the order dated 12/12/2025, the petitioners were granted interim bail with conditions. The said interim bail shall continue till the next date of listing. List on. You can suggest a date after vacation now. 5, 6, let it be 6th. No? 5th of May or 5th of May, 5. So, same, no?
Interim is
Case diary is issued in my same order. Interim is 9/1/2026. Okay. Date is also same 5/5/5/5.
published. Lordship, can it be 6th?
Yeah,
6th.
6/5.
CD received, but PM report not available.
There's no interim. Pending for a long time now.
May I please, Lordship.
You're here?
Lordship,
PM report is not received, he says.
But my lord, what happened in this particular case that my lord, the co-accused already granted bail, lordship. Kindly look into the my lord, page FIR, my lord, for a moment, my lord.
Yes.
Original FIR I am coming, my lord.
Okay.
Page 19.
Yes, 19.
Yes, lordship.
You want to read it? You want to read it?
Yes, my lord.
Honman.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে ৩ নং পদকীজনে মোৰ বাবাক মাটি বিক্ৰী কৰিম বুলি কৈ মোৰ বাবা জুলাজুৰৰ পৰা নগদ ৫ লাখ টকা আজি প্ৰায় ১ বছৰ আগত লৈ কোনো ধৰণৰ মাটি নিদি পদকীজনে নিজ বস্তিত ঘৰ এটা বনাই আমাৰ মা বাবাৰ ভাই ভনী সহ ৫ জনীয়া পৰিয়ালে এবছৰ ধৰি বসবাস কৰি আছে। পদকীয়া ১ নং মোৰ ভনী চাহিদা খাতুন বয়স ১৭ বছৰ ৬ মাহৰ পদকীয়াগণৰ বস্তিত থকাৰ সুযোগ লৈ প্ৰায়ে ভাল পোৱাৰ বাবে জোৰ জুলুম কৰি থাকে। অৱশেষত সিহঁতৰ মাজত প্ৰেমৰ সম্পৰ্ক গঢ়ি উঠে। যোৱা ইংৰাজী ২/১২/২০২৫ তাৰিখে ৰাতি ১১ বজাত আমাৰ ঘৰত অকল বেমাৰী পিতা থকাৰ সুযোগ লৈ ১ নং পদকীয়াই মোৰ ভনী থকা ৰুমৰ ভিতৰত সোমাই গৈ মোৰ ভনীজনীৰ লগত আছিল আৰু মোৰ পিতাই ১ নং পদকীয়া ঘৰৰ পৰা ওলাই যাব কোৱাত মোৰ পিতাক চিগাৰেটৰ লগত নিচা খাৱান কৰাই অচেতন কৰি মোৰ ভনীজনীক বাকী পদকীয়াগণৰ সহযোগত প্ৰাণে মাৰি পেলাই গলত ফাঁচি লগাই আত্মহত্যা ৰূপ দিয়ে। কিয়নো ১ নং পদকীয়া অন্য ঠাইত বিয়াৰ বন্দোবস্ত হৈছে। মোৰ ভনীজনী ১ নং অন্য ঠাইত বিয়া কৰিব মানা কৰাত তাইক মাৰি পেলাইছে। There is no IGTs, my lord. That actually what happened, my lord. There is a dispute going on between that, my lord, family victim fathers and that the accused fathers, my lord, about a land dispute, my lord. That is going on, my lord. That is a admitted position. And my lord, what happened? There is no idea. And my lord, mixing in substance in cigarette, my lord. That boy is a 25 years boy, my lord. And both are the victim girl and that boy is a cousin, my lord. And she offered marriage, my lord, but he refused, according to them, my lord. And that co-accused already granted, my lord. Why I am, my lord, police is searching, my lord. He is ready to cooperate with the investigation officers, my lord. And the last CD also, my lord, when we have said nothing found against material against that accused persons, my lord. Kindly examine, my lord. That is my thing, my lord. And Supreme Court also, my lord, so many cases is primacy law, if that, my lord, they are not unable to satisfy this court, then, my lord, he is entitled to gain bail, my lord. Bail is a, my lord, rule, my lord. And jail is exception. A young boy, my lord. Only, my lord, can it, my lord, cigarette or logo nisa hawan korai. The father, my lord, whose age is 60 years, my lord, and 24 years offer a cigarette, my lord.
Case diary has come.
Yes, my lord, kindly
Statement of the witnesses in the brother.
Kindly examine, my lord.
Then accused is the accused number 1, who has, there is some relationship with the. And informant is Dulhas Tukil, he is the brother-in-law of the accused petitioner number 3, Jamal Ali, my lord. They were staying in the same compound, my lord. And my lord, on the day of the incident, my lord, some of the witnesses also there, and but he is the person, my lord, who first told that, my lord.
The father, my lord, according. Then he is already granted bail, my lord.
This is the statement of the accused number 3, my lord. বাপেকে উঠি ছোৱালীজনীয়ে ফাঁচি দি মৰি থকা দেখা পাই চিঞৰ বাখৰ কৰে। তেতিয়া মই ফাঁচিৰ পৰা ডেড বডিটো নমাই আনিম। কথাটো মই
This is the statement of Jamal Ali.
Jamal Ali already got bail, my lord. He is in bail.
কোৱাকৈ ফাঁচিৰ পৰা ডেড বডিটো নমাই চোতালত ৰাখো। মোৰ ল'ৰা আহমেদৰ লগত ভাল পোৱা সম্পৰ্ক আছিল বুলি শুনিব পাওঁ।
Postmortem report will be not necessary.
Postmortem report, my lord, regarding whether this is a case of suicide or cause of death.
Cause of death needs to, yeah, PM report is not there at all. Get the PM report.
My lord, last 6 occasions they are not placing that PM report, my lord. And my lord.
Otherwise,
that
we'll have to dispose
police
it.
is searching, my lord, interim protection at least.
No,
my
no,
lord,
no.
that
The
Young guy,
main
my
ele-
lord, 25
No,
years.
young guy, but this is a younger girl, the deceased.
The co-accused, my lord, who is the
What about the
father-
victim? She's a younger girl.
Father, my lord, already got bail, my lord, who was giving the statement, my lord.
Anyway,
My lord, kindly look into that, my lord, and kindly, he is a young guy, my lord, on that day, he was not, my lord, only because of, my lord, my lord, only, and that informant, my lord. The informant is not that, my lord, that daughter who is staying in, my lord, Borpeta, my lord. No eyewitness, nothing, my lord. Both two
These are
FIRs
subject
already
of
get
investigation.
Jamal Ali also got bail, my
Subject
lord.
of investigation.
And my lord, Jamal Ali and my lord, Munir Ali both have get bail, my lord. I am ready to cooperate with the investigation officers, my lord. No eyewitness, nothing, my lord. Can it possible to, and there is a my clear-cut case of the, my lord, civil nature, my lord.
Civil nature?
Yes, first part is that, my lord, there is a dispute is going on. Everybody knows, my lord.
See, anyway, some allegations have been made, but I don't know whether we should dispose it off or keep it
my
for
lord,
PM.
Kindly, my lord. Kindly look into the city itself, my lord, then. Last 6 occasions they are not.
Let me have a look.
Because he is accused number 1. And your lordship may kindly.
Main allegation is against him.
My lord, kindly examine, my lord.
These
There
are,
is dispute going on. It is admitted position, my lord. Due to the land, my lord. Both are family.
That aspect also.
My lord, my
Don't
lord.
worry, I'll see.
Regarding witnesses, then was also. In fact, he can
No, this is a regular bail. Here in the AB, actually this petitioner
Yes.
is a brother of A1 and he's staying in a different place, actually. So probably that's why he was, he said that he was roped in unnecessarily. Let us see this.
Before that.
What have they stated?
Someone stated that before the incident, they in fact were regarding pretending. The accused person pretend the family of the victim, that is also there. Before the incident.
Because he's alleged that he has been killed, right?
Yes.
So, but the postmortem report might indicate whether the hanging is ante-mortem or postmortem. So, I think it will be, I think, advisable to see the.
My lord, kindly look into that 9 February orders, my lord. 9 February, 13 February, and 20. Every time, my lord, honorable court is sought for that PM report. They are not placing. And now, my lord, that is why, my lord. And that, my lord, police also searching, my lord. They are sometime, last occasion, they are placing that, my lord, CD up to the CD before your lordship. And, my lord, they are not able to finally satisfy this court also, my lord. I am a young guy, my lord. I am ready to cooperate with the investigation. No one kindly look into that affair against my lord. First part is purely in civil nature. Second part only I refuse to marry her. No, nothing, my lord. No relation, physical, everything, my lord. Only that saying that more pitak cigarette logo nisha hawan kora oseton. How she came though? She is staying from in Borpeta, my lord. She is a married girl, my lord.
482.
Page 19, my lord, original.
Okay, Ahmed Ali.
Last page, 1 নং পটিকা ঘৰৰ পৰা ওলাই যাব কোৱাৰ মোৰ পিতাক চিগাৰেটৰ লগত নিচা সেৱন কৰে. Can it possible, my lord? 25 years boy, my lord, offering a cigarette to a 60 years man, my lord. Can it possible, my
Anyway,
lord?
so Azhar dated for the allegation in the FIR dated, the case arose out of an FIR dated 4/12/2025 lodged by Jarina Khatun, naming 3 persons therein, including the present petitioner as A1. A1. It is alleged that A3, accused number 3, Jamal Ali, had taken an amount of 5 lakhs from her father regarding sale of a land, but has not sold the land. And but he has been staying in the land of the what is this? Sell a plot of land about one, but not sold the land. And my family members, father, mother, so and so, have been staying in the accused residence. And that her family members have been staying in the land by building a house from the last 1 year. Full stop. It is further stated that the accused number 1 / the petitioner developed a love relationship with the informant's minor sister aged 7 years, 6 months. It is stated that on 2/12/2025 at around 11 p.m., the petitioner entered their house, taking advantage of their ill father staying alone. And when he tried to drive him away, he made him unconscious by giving him a substance. And thereafter, the petitioner / A1 intended to marry another woman, to which the victim / informant sister had objected. The informant has alleged that her sister was killed by the accused persons in a pre-planned manner. So, the learned counsel has placed 2 bail applications whereby Jamal Ali was granted regular bail by coordinate bench of this court, and another accused, Monir Ali, granted anticipatory bail by another another coordinate bench of this court. Full stop. Upon perusing the said order pertaining to pre-arrest bail, I find that the applicant therein stated to be the brother of A1 and son of A3 was said to be residing at a different place. And it was contended that he was roped in mainly because of being a family member. Full stop. The case diary has been received. However, the PM report is what should we do? We'll dispose it off, or PM report should be procured. The PM report is not available. The learned counsel submits that the matter has been pending for several dates for the PM report. Full stop. Peruse the statement of the witness as well as one co-accused. Full stop. Witnesses and co-accused. Investigation is still in progress. Full stop. Considering the nature of the allegations and the fact that investigation is still in progress, at this stage, I do not deem it proper to grant anticipatory bail to the present petitioner, who is arraigned as the main accused in the FIR. Full stop. In such view of the matter, the bail petition stands rejected. At this stage, return back the case.
My lord, can it be fixed some other day to PM report?
No, I asked you several times.
Despite of my lord rejecting my lord, as a date, my lord, young boy, my lord, then
you
I have
insisted
to
so
come,
many
my lord,
times
young boy,
about
my
the
lord,
FIR, about the PM report. No, anyway, leave it. So it's okay. Next time you can file it again. No issues after the investigation progresses. Okay. Next matter.
Oblige, Lord.
I'll be at a minute. With my actually, we have I try to get the instruction from.
Oh, the instruction, right?
From Jalukbari police. So in our file, it is written as Jalukbari police. Now here submitted from Panbazar police station.
Panbazar police station. Then keep it for tomorrow or day after. Day after tomorrow.
In the meanwhile, maybe
Tomorrow.
tomorrow.
You are not sure about which Panbazar police?
Panbazar. I have stated Panbazar. Yes.
Panbazar police. The did we dictate? The learned additional PP submits that he has to take some instructions from the Panbazar PS, where the petitioner is apprehending lodging of a complaint or case Full stop. List the matter tomorrow. Okay.
Well, obliged.
Meeting at 58.
Yes.
Wait, please, Your Lordship. So the case diary has come. But you remember this case, my lord, there were
Yes, yes.
multiple cross cases, my lord.
Yes, Ranjan.
Subject to what is there in the case diary, my lord.
I'll go through if necessary properly.
Incident is separate file. Here's an incident and happened on 8/12/2025. He's accused person.
The bail, the case in which you are seeking bail is
768.
768. Tezpur 768. Right?
Yes. 39 weeks.
The date of incident 3/12 at around 8 p.m.
We got both the case diaries.
Only one, the present case diary.
In this case,
768.
yeah, in this case, only 768 was called for.
Okay, that will do.
Yes, my lord. Separate it.
Jury report also required.
You can flag it. I can go through it also later on properly. No, you can submit, make your submissions. Will you submit? You will
No,
submit.
after he submits.
Okay, you make your submissions. I'll note down.
Staff are involved in.
And thereafter, if necessary, I'll see it later.
The incident occurred on my lord here from the FI 3/2025 at around 8 p.m. All these accused persons were initially confined one Rizwan Ahmed. Thereafter, my lord assault tried stealing with a rope and thereafter assaulted. Regarding that aspect, my lord supported by the statement of the witnesses also, eyewitnesses also there, my lord. And two injury report, head injury also there.
Simple. Mutual market.
Mutual market, my lord. Because your lordship, remember the incident originated beforehand. This was a separate incident of 3/12. But prior to that, there was initially the petitioner side who were subjected to injuries, my lord. And lordship may go through this, my lord.
Blunt object, simple injury. One.
Yes.
One of them. No? All the injuries simple.
Simple.
Victim has supported.
Since the injuries are simple in nature, my lord, so my lord, I will not go into the other aspects, my lord. Considering the simple in nature of injury and 45 days in custody, my lord.
Unity is there between all of them.
My lord.
Earlier 764, 2025,
6 years. 764 to listening.
Yes, Nawaz, learned counsel for the petitioner and additional people. Invoking 483 BNSS, the petitioners so-and-so are seeking regular bail in connection with Tezpur PS case number 768 of 2025 under so-and-so section. You can write from here.
Yes, 39 is the offense.
39?
Sorry, man. Yes.
Yes, 39.
39, man. Yes, motion.
I can write from here also. There was this 766. Which is the FIR? Where is the FIR of the 768?
My page 39, man.
39.
39, 40.
39, 40.
LXR 9. 39, 49.
The case arose out of an FIR dated 4/12/2025. Erring lost by
Was the one Abdul Aziz Khan, my lord. 39
End part, my lord.
Um,
39, the.
Yes, yes. Arraigns 9 accused persons therein with the allegation that on 3rd December 2025, in the night around 8 p.m., while he was going to his shop, the accused persons named in the FIR confined his nephew Rizwan Ahmed, tied him with a rope and assaulted him on his body parts. Full stop. And later, when he along with his other son proceeded to the spot, they were also assaulted. I'll not write much. The case diary as called for has been received. Full stop. The statement, in his statement, the alleged victim Rizwan Ahmed has supported the allegations. Full stop. The medical reports are also available of 3 alleged victims, including Rizwan Ahmed, and all of them indicate simple injuries with blunt object. The petitioners are in custody since 20th February, that is, after their arrest. Full stop. I've seen the progress of investigation. Full stop. Considering the length of detention, the progress of investigation, and the fact that though victim has supported about the assault, but the injuries are medically labeled as simple, no? I deem it proper to grant bail at this stage. In such view of the matter, how many petitioners are there? 25,000 each. 25,000 each. The surety of the like amount each to the satisfaction of the CJM, Tejpur, subject to the conditions. 3 conditions. Cooperate with remaining investigation, not hamper and temper. Shall not misuse their liberty to commit any illegal activities or offences. They shall not harm the informant side in any manner. The violation of the bail conditions might entail cancellation of the bail. Return case diary.
I'm deeply obliged.
It was 14.
May please, your lordship. Petitioner before your lordship is the second time bail petition, my lord. The FIR is page 13, your honor. But there in the FIR there is no allegation against the present petitioner, your lordship.
So we had given a direction.
Yes.
Seized whether activated and whether the fingerprint scanner. Yeah, this order was not marked to you. Anyway, I was directed to submit a report indicating whether, along with the case diary, as to whether the seized recovered SIM card was activated, whether the fingerprint scanner recovered were in order or not at the time of seizure. That part you see, just see.
My lord, kindly see the page 22, my lord.
Where is the earlier bail application?
Earlier bail application annexed to
page
18. And there's a findings by your lordship, paragraph 5.
No recovery, but okay. So in that backdrop, you said that
yes,
let it be
because
ascertained.
the petitioner is having a shop where he is selling the SIM cards. The SIM cards were activated by the company,
the allegation.
Not by the petitioner.
By the customers, not by him. Activated by the customers.
Activated by the company. Company after verification of all the documents, not by the customers, not by the petitioner also. He just to sell the SIM card. And now kindly see the page 22. All the other all the accusers released on bail. Page 22, paragraph 2. This is a observation made by the learned court below, my lord. May I read?
Page 22.
Page 22. May I read, my lord?
Yeah.
Case that is received and perused, it appears that the accused was apprehended by the villagers and handed over to the police, and the accused were found in possession of several suspected SIM cards.
The case diary also shows that investigation is almost complete and these articles have already been taken into the custody. No further recovery remains to be affected from the accused persons, my lord. In this observation, it seems, my lord, that the investigation almost completed. Even then, my lord, whether any custodial interrogation is necessary or not, that has to be decided by this honorable court. Second, my lord, the two person before your lordship filing the anticipatory bail application, one is allowed, another present petitioner rejected. Earlier lordship is and there is the Supreme Court says, my lord, ground of parity, my lord. In that case, my lord, if the other
If facts are broadly similar, then parity should be applied. Otherwise, it may differ.
Yeah.
If facts are broadly similar, then parity should be applied.
yes,
Otherwise,
parity,
it will be unfair.
that is the judgment.
Yeah, sure. I'll see it. So kindly see that
Election is
aspect.
same, my lord.
Kindly see that aspect.
And there is no link that this petitioner is, my lord, selling to
Any fraudulent Aadhaar cards.
yes, activated SIM card or not. And 105, my lord, BNXS, my lord, saying that during seizing, my lord, seizing articles, my lord, there needs to be a, my lord, videography or audiography. But the police did not do the same, my lord. So in that ground also, my lord, this petitioner is released on, my lord, anticipatory bail. And almost the investigation is completed, my lord. Custodial detention is not necessary because all the accused are interrogated. And if lordship is directed the petitioner, he also available before the IO.
Well, interim or granted? Interim, he's on interim.
No, no interim. Because this is a second.
Where's the rejection order? Can you
order
repeat the page number, please, once? The earlier
18,
order.
18, page number 18.
This is an allowed order.
No. Well, partly allowed.
Oh, it's a partly.
There is a two accused, my lord, Nasiruddin Ahmed and Rakibul Hussain. Nasiruddin was allowed.
Grant, now Rakibul is seeking the
yes,
bail.
My lord,
Okay.
My lord, here, earlier it was rejected by the after going to the case.
One was allowed, one was
Rejected. Here, petitioner has no any ground, new ground, my lord.
yes, my lord. Kindly see the paragraph 12, my lord.
Judgment also, my lord, subsequent bail may be only when they
Paragraph 12, my lord.
But here they have not placed any new grounds, my lord.
And the paragraph 12, my lord. Kindly see.
The second argument is that, my lord, SIM card, regarding the SIM card.
No,
my
we
lord.
can also sometimes say subsequent ground can also be, it can also be considered from the point of view of the court, from the side of the court, suppose length of detention, additional progress of investigation, or, investigation may be completed, which the petitioner sometimes may not know sometimes. Like, that is okay, slightly flexible. But from his side also, if he has some new grounds, that must be written, of course. You said that para 13.
Para 12, my lord.
Oh, let's see, now.
My lord, after, my lord, registering this case, the police are severely went to his house. Her
Calling
mother
him
was, my lord,
anyway,
hypertension, and that
statement.
there is a medical document. If lordship you want to see this.
Anyway, so I'll complete.
My second part is the owner of Air Enterprise situated at Burma Market, my lord. He is the owner, my lord. From whom all the wrongful works were done.
Okay. Has the investigation lent support to the allegations about fraudulent Aadhaar?
My lord, here is the, my lord, from the Air Enterprise, my lord. It was, lordship is earlier occasion also, it was reflected at 41 numbers of
Air Enterprise.
that is recovered, my lord, from the house. And some of the witnesses their examined. Here, they have said that, my lord, you may read 11.
Yes, you can please read.
যোৱা ইংৰাজী চোৱাঞ্চো তাৰিখে মই সিহঁতৰ পৰা ঘৰলৈ আহি থাকোঁতে তিনিআলিত মোৰ চাৰিজন বিশ্বাসে ৰখাই আৰু কয় যে ইয়াত সি চিম বনায়। পিছত কি লাগিব কোৱাত আমাৰ আধাৰ কাৰ্ড লাগিব কয়। পিছত মই বনাওঁ যদি মোক 5-6 বাৰমান ফটো মাৰে। 5-6 বাৰমান ফটো মাৰে।
Free SIM means? Like free SIM means?
They have taken the Aadhaar card for one,
Achha.
but SIM was for 4-5 numbers of SIM.
But how can it be possible, Lordship?
Let me explain my submission complete.
ঠিক আছে।
You will have the chance to minor. পিছত এক্টিভ হয় যদিও সন্দেহ হোৱাত মই মাই আধাৰ চেক কৰোঁ। পিছত মোৰ নামত সিম 4-5খন এক্টিভ হোৱা দেখায়।
Achha.
আৰু বায়োমেট্ৰিক কৰা দেখায়। পিছত ৰাইজে মিলি তেওঁলোকক আটক কৰোঁ। And other witnesses are also not seen and want to regarding the active.
You can read those also. No, if you want, you can read.
Another.
Okay.
I have read that only one month.
You ran away.
Well, after Lordship kindly spirit a statement of Iftikar.
Iftikar.
Well, quick. Have take much. The present petitioner has sent a different person to different places for that purpose, my lord. The present petitioner has sent a different person, group, my lord, person, different places for free, my lord, SIM card, my lord. But after taking the Aadhaar card, they have produced 3-4 SIM card, my lord, for one Aadhaar card, my lord. That is also allegation.
Now, my lord, my humble submission is that those person was arrested, they are not saying the name of the accused person, my lord, present petitioner's name.
No, it is there. This one from.
Only one, my lord, that is, my lord, under the influence of the police custody, my lord. So the SIM was, my lord, activated by the company. There is in every SIM there is a ICCID number, my lord. If petitioner is activated, that how can it be possible, my lord, petitioner can activate that SIM?
See, identity manipulation is a serious offense generally, and more so in this part of the country, in border areas or for special reasons, as you know, for obvious special reasons. So therefore, this has to be, it's not to be taken very lightly. Of course, there has to be proper fair investigation, only if there are materials, okay? This appears to be.
That case, my lord, almost my investigation is complete. The custody detention has to be decided whether custody detention is necessary or not, my lord. And
Just let me see.
the picture location.
the heard, your good name, please?
NC Das.
NC Das, learned counsel for the petitioner. And B. Sharma, learned additional people. So we have, an earlier bail petition was rejected on behalf of the petitioner, was rejected on 19/12/2025 in AB 2783 of 2025. Full stop. Though it was allowed with regard to co-accused Raqibul Hussain. For the Nasiruddin, accused, present one is Raqibul Hussain. Though it was allowed with regard to co-accused Nasiruddin for the reasons indicated in para 5 of the said order. From that order, you can take para 3 as the allegations. Para 3. Full stop. So, learned counsel thus admits that he is having some health problems due to the tensions with regard to the instant case. Semicolon, that comma, all the materials have already been recovered. All the alleged materials have already been recovered. And that granting of bail to him at this stage may not hamper investigation. Full stop. Learned counsel submits that referring to a decision of Honorable Supreme Court that in the case of Kamaljit Singh, State of Punjab, 2005-7 SCC 226. Learned counsel submits that on the ground of parity, the bail petition of the present petitioner should be considered. What were the materials with regard to the other? We have already granted bail, but was he equally implicated?
No, my lord, they have not recovered anything from the
From him.
my lord.
Yeah, that is that we have recovered management. Five persons are named in the FIR, including the present petitioner.
The present petitioner name not mentioned in the FIR.
Not named in FIR.
Not named FIR, madam.
Full stop.
The named FIR all are released on bail.
All are released on bail.
All are released on.
5 persons are named in the FIR. In this context, the learned counsel submits that all of them have been released. Is that true? All of them are released on. That is his instruction.
There is
all of them have been released on bail. Some by this court and some by the learned court below.
Yes, madam.
Full stop. Then but there are materials against him. Direct materials against him. Accused Iftikhar Hussain. Can you have a look again with regard to the, just have a look again to the other accused. Other accused.
But from the present petitioner, it was
Recovered.
So that seems are activated or not, that has to be.
The learned additional PP submits that there are no sufficient grounds in this subsequent petition, and that the incriminating materials have been recovered from the shop of the present petitioner. It is submitted by the prosecution that from the investigation materials, it has been revealed that with regard to a single Aadhaar card, multiple SIMs were activated, and that same has been supported by the statements of witnesses. Good stuff. I have perused the relevant portions of the case diaries. The seizure witnesses have supported about the seizure of the materials from the. He is the owner of the shop.
He is the owner of the shop.
Owner of the from the shop. Seizure of the materials from the shop AR Enterprises, which is owned by the present petitioner. The statements, the witnesses have also stated about finding that multiple SIM cards have been activated on the basis of the same Aadhaar card, and later when they tried to apprehend the culprits. Some of them ran away. Stuff. Then it may not be justified to some extent.
They are arrested, man. Thereafter, they are released.
Some of them all are arrested.
Arrested.
All are arrested.
Investigation, as the investigation is considering the nature of the materials revealed and as investigation is not yet completed, it may not be prudent to grant anticipatory bail at this stage. Full stop. It's still not completed at this stage. Full stop. In such view of the matter, I am unable to find sufficient new grounds in this petition. In the subsequent petition, which also accordingly stands rejected at this stage, return back the case directly. Okay. Adjournment.
Wait, please, Your Lordship. My lord, is item number 41. And my lord, and also 42 is also, my lord, from the same FIR. my
Same
lord.
FIR.
So now I'm on 41 now. So Your Lordship kindly see in 41 only one petitioner here. The 41, my lord, Your Lordship kindly see the FIR page 20, my lord. Page 20. I will read the my lord, vernacular, my lord.
Okay.
May I read it, page 20, my lord?
Yes, please.
মাননীয় ভাৰপ্ৰাপ্ত বিষয়া মহোদয় নলগাঁও আৰক্ষী থানা বিষয় এজাহাৰ মহোদয় বিনীত নিবেদন এই যে যোৱা ইংৰাজী 5-3-2024 তাৰিখে ৰাতি প্ৰায় 12:30 বজাত নিম্ন উল্লেখিত পদকীয়াগণে AS013 AS8062 নম্বৰ গাড়ীৰে অস্ত্ৰ লৈ দলবদ্ধভাৱে মোৰ মাটিত প্ৰৱেশ কৰি মোৰ মাটিত থকা বেঙেনা খেতি গছ বলপূৰ্বক উঘালি পেলাই দিয়ে আৰু দেখা পাই বাধা দিব যেতিয়া পদকীয়াগণে মোৰ পিতৃ জমি আলী মোৰ স্ত্ৰী মমতাজ বেগম দাদা ইনামুল মইনুদ্দিন আহমেদ 40 ভতিজা ল'ৰা মুন অমৰ বয়স 6 ডেগাৰ লোহাৰ ৰড আৰু চকা অস্ত্ৰৰে উপযোগী কৰি মাৰপিট কৰি আটাইকেইজন লোকে শৰীৰত বিভিন্ন অংশত গুৰুতৰ আঘাত জখম কৰে পিতৃ জমিৰ আলী আৰু স্ত্ৰী মমতাজ বেগমৰ অৱস্থা সংকটজনক হোৱাত দেলগাঁও থানাৰ আৰক্ষী অৱগত কৰাত ঘটনাস্থলীৰ পৰা পদকীয়া জখিমীক উল্লেখ কৰি তাৰিখত খাৰুপেটীয়াৰ হস্পিটেললৈ লৈ যায় তাৰ পৰা চিকিৎসকে আসামীগণক GMCHত প্ৰেৰণ কৰে যদিও পিতৃক উন্নত চিকিৎসাৰ বাবে গুৱাহাটীলৈ এইমজলৈ ভৰ্তি কৰায় এইমজত চিকিৎসকে চিকিৎসা আদি উক্ত দিনাই ডিচাৰ্জ দিয়ে পিতৃক তাৰ পৰা লৈ অহাৰ পথত দিনৰ অনুমানিক 4:45 বজাত পুনৰ অসুস্থ হৈ পৰাত আমি সিহঁতক পিতৃক লগে চিকিৎসাৰ বাবে NCHত লৈ যাওঁ যদিও চিকিৎসাৰ চোৱা হোৱা কৰি পিতৃক মৃত্যু ঘোষণা বুলি ঘোষণা কৰে পদকীয়াগণে মোৰ পিতৃক বসুৰ মাৰপিট কৰা বহুতভাৱে জখম হোৱাত মৃত্যুবৰণ কৰে প্ৰকাশ থাকে যে মৃতকৰ ধৰ্মীয় সৎকাৰ কৰা ব্যস্ত থকাৰ কাৰণে এজেহাৰ দিয়াত পলম হ'ল গতিকে দয়ালু মহোদয়ে বিষয়টো পৰ্যন্ত কৰি পদকীয়াগণৰ বিৰুদ্ধে আইনগত বিহিত ব্যৱস্থা লোৱাৰ প্ৰাৰ্থনা জনালো Now Your Lordship kindly see there are 13 and 14 accused person names here.
Okay.
So I am representing in this case my lord serial number 12 that is Nazrul Islam.
12.
He is the Gaubura of the my lord that village. And all these 14 all the names of the my lord that locality has been given there my lord. In 12:30 night that my lord they went there that is the my lord there is a civil suit pending between my lord accused number 6 and the complainant my lord. That is the different issue my lord. My submission before your lordship that discharge certificate given by the AIMS my lord. That is a very important piece of evidence.
Nazrul Haq is the Gaubura
of my lord
number A12. Accused number 12.
Accused number 12. So that is item number 41 my lord. So his Gaubura my lord, his name is my lord, although there is no specific allegation as anyone my lord, but because in my lord, now this is my lord election season my lord that politics is going on and all the names of the my lord their opposite parties has been given here my lord. So my lord, may I pay that my lord the discharge certificate of the AIMS because he was admitted in the AIMS. The AIMS my lord discharge certificate given. So in the discharge certificate everything has to be written my lord. So whether he is died because of this incident or my lord something else my lord.
Discharge certificate is available.
Because in the FIR itself stated that my lord is discharged from the AIMS.
PM report is here, my lord, available.
Hmm.
But here, that are,
Oh, no.
my lord, here, PM report shows, my lord, opinion, my lord, cause of death, my lord,
Okay.
coma as a result of head injury.
Acha.
And
Coma.
lordship, I have checked back, my lord, there are 11 numbers of injuries in his body, my lord.
Okay.
11 numbers.
Quite a few.
Lordship may kindly see 11 numbers of injury.
That is one aspect of the matter.
My lord.
Now we-
Fracture in light,
Oh,
electric, my lord.
yeah, yeah,
Say
serious
back,
injury.
I have checked back, my lord.
Serious injury. The most important aspect with regard to this application is that this
Yes.
involvement of this person.
This-
has to be seen, which is not so easy in a group fight.
Here, my lord,
But
some
still,
witnesses examined, my lord.
Zamir,
All the witnesses said that, my lord, some of the persons are involved, my lord. Regarding Nazrul, my lord, he is involved as per statement, my lord. He is also there, my lord. And regarding others, my lord,
My
No,
lord,
there-
already
no.
3 persons were arrested. No,
no, in this petition, he's only one.
Only one.
Just let me check, huh?
and
Nazrul, in item
Item 41.
41, Nazrul.
Nazrul Mal. In the other petition, my lord, there are 4 petitioners.
Four petitions.
5 petitioners.
5 petitions. 1 plus 5.
No, gone by.
You have to
That
check
one
it separately.
I'm
Because these cases, no doubt, there's some serious injury, death
My
has
lord.
taken place. But who has done what, it's not easy also to find out.
তো ঘটনাত মই তাত থকা মানুহবিলাকৰ ভিতৰত তকদিৰ আলী, মহম আলী, শফিকুল, হাবিবুল্লাহ, মুক্তাৰ হুছেইন, মহম্মদ আলী, শাহজাহান আলী, মুছা আলী, আজিজুল, জাহাংগীৰ আলম, সাইদুল, মানে দেউতাৰ some of them, my lord. Here Nazmul, Kaupura, here is also.
He is also there.
there, my lord. And Tofazul is there. Tofazul. Next item. Amaz is there. Amaz.
Proposal next item number here.
Itu দিব, itu item 2. Itu item 40, itu দিব, next to this. একেই হয়। Nazmul Haq, then
Tofazul in the second petition, my lord. Tofazul and Amaz. And they are also said that others also. The violent person.
others. Then maybe, what is the third name you mentioned? Amas? Amaz, acha.
Amaz, my lord.
Acha.
Three, my lord.
I did not get it.
I'll come to that, my lord. Kya naam kolo bilkul? Amaze.
Make the submissions.
That's okay, fine.
Otherwise,
My lord, at 12:30 night, it is, my lord, very difficult to identify anyone. Anyway, my lord, but what is the specific allegation against the whom, my lord?
very difficult. This
Very difficult. Very
to
difficult.
determine. Very difficult. And there's,
Lakshmi, kindly 1 second.
there's a risk is on both sides. I will see it.
But my lord, in discharge, how that can be discharged from the aims, my lord? Then the FIR also it is revealed that, my lord. If it is so, then my lord, discharge from the aims.
Hmm.
That is their own statement.
That means they did not examine, I don't know what.
PM report there is there.
Yes, yes. PM to you have already narrated.
Get the injury.
The injuries, it's 11 injuries, my.
I know, this head of the kiya jabe.
A lot of
120
injuries.
national killing.
Lot of injuries.
Share of the kiya jabe.
Lot of injuries.
Seven.
That's true. But cannot be such a person, how can it be discharged with first aid? That is also there. He must be with after sustaining
Kita
some.
must quit.
So this kind of injuries, a person will be unconscious.
Yes, obviously, my
Usually,
lord.
likely to be unconscious.
Because no, that is their own statement that he is discharged from the, my lord, hospital. And after that, my lord, he went to the house.
You know what he meant by discharge, or they maybe took him.
Discharge means they want to take in another state for better treatment.
Oh, yeah, that maybe I don't know, but
Even then, there should be a discharge certificate. There should be a discharge
Ah,
certificate.
discharge. Yeah, you are for the informant.
My,
You make your submission, then I'll come back to reply.
yeah, yeah.
Hmm.
Kita
As per Nazrul Haq, being a Gauhati, he by increasing the official position, my lord. He said, my lord, there is a Bahini, my lord. He has a group, my lord. And he used to grab lands, my lord. And this way, my lord, we represent petitioners' land also on the day of office, my lord. In a designed manner, my lord, they came up with a car having, my lord, armed with dagger and other sharp weapons and started to attack on us. And we usually my father.
Informant is the brother.
My lord, my father, informant's father.
Your father. Yes.
So
Yes.
I just clear objection,
Okay.
but if they get bail, my lord, they will attack again, my lord. Rest of the family members. They are always stating that one we have taken away, others if bail, let us get bail.
Anyways, I'll see it properly. No, I'll not dictate it here. I'll see it little carefully.
I have also filed one objection, my lord. All are FIR in exist here.
Only that allegation, my lord, but
I'll
what
see that
does
also.
provision say? And
I'll
3-4 persons already my line, only 3-4 persons arrested.
Okay. I will see. I'll
Fine.
see it carefully because these group fight cases are very risky.
My lord, very difficult subject.
No, very
Different
risky also.
persons are-
Risky on both sides actually.
My lord, no, there is a cross FIR also, my lord, here.
Cross FIR also.
Is there. Certified copy to the.
Submissions are same for both the matters.
My lord,
Both
my
the-
lord,
Broadly same.
all right.
So let me see it.
My lord,
Let me give some time to it. See it, better to see it carefully.
all right.
Stop dictating it here.
Police.
পুষ্টিৰে সামনে হৈ যাব এইটো লগাই দিয়ক
Give
I'll see
you
it
a-
properly.
নালাগে দিব কিনা
আৰু এটা আছে ন chocolate?
হেৰি হ'ল কি আমি
এটা আছে।
হাইকোর্ট
Silver dictation মানে কোনটো আছে? Silver dictation, এই এটা আছে, এইটো দি দিম। 61.
61.
Your lordship,
Yes,
the conducting counsel is on his legs, praying for
after some
time.
time.
Yes.
This, just a minute, it is, scan record has come. This has come. We'll take it up after some time. Okay. Serially দিয়ক আৰু। Bill হৈ গ'ল ন? Orders নাই, admission দিয়ক, serially দিয়ক, serially দিয়ক। serially.
My lord, Miss Regulation. This matter is adjourned for today, my lord, may be taken after, immediately after view.
No. There's a order of stay, right? Oh, as you wish. We finished bail, but anyway, as you wish. Okay. The learned counsel for the petitioner seeks an accommodation today and prays for listing the matter after vacation. The learned counsel for the respondent number 2 fairly does not object to the same. The interim order passed by the order dated 12/4, it's a long time, no? Passed earlier, shall stand extended till the next date of listing. On the next occasion, we can try and do it. Huh? This is a NIAC matter.
Yeah, no,
NIAC matter.
yeah.
List on, you take a date then.
Okay.
Scan record is available. 9 May.
19th of May.
19th of May, that is a Tuesday. Yes, we can. We can. Should I fix it? 19th of May? 19th of May.
Bless me.
I know. The Dimma matter, it appears. Excise departments. তেওঁলোকৰ অহা নাই কোনো। After, shall we fix it? No. None appears on call. Full stop. Scan record was called for. Record. Asani. Will not require any scan record.
Right.
Will not require any scan record. Yes.
Also, excess is there, ma'am.
So anyway, list the matter on 21/4. 21/4, yes. 21, 22, 23. Yes. Yes. These are appeal against enact. Criminal revision against concurrent findings of guilt. It's better to do it in the form of a hearing, proper hearing. Should I admit it and fix it for hearing after reopening? Sometimes it is possible, but usually what is
You fix the matter on the hearing day, my lord, for admission hearing.
hearing day? Actually, we should give priority to hearing matters, but it's a 24 matter. On a hearing day also, it may be possible to touch it.
Since you have this division
touch
petition,
it.
my lord, I'm not getting the money.
Yes, that is a
There's a direction on 17th.
20%. You are the complainant. You are the complainant. You are definitely aggrieved, no doubt about that. Please not come today. None appears on call. Full stop. You are appearing for the respond number 2. Right?
Fine.
Good name, please.
IS circuit.
IS Circle, Learned Counsel appearing for the respond number 2 complainant. Respond number 2 or sole? Sorry, respond number 2 / complainant. Submits that due to pendency of this criminal revision, the money pertaining to the check is also locked up from his point of view. Then what do you suggest?
Fix the matter, my lord, on the hearing day in the month of May, my lord, first week of May, my lord, on 5th of May, possible, my lord.
Let's not. Fixed, we have fixed several matters. A little later.
Fine. 14th.
We can fix it on 7th May or 12th May. 7th or
12th May, my lord.
if it is okay for you. Okay.
In the meantime, what happened, my lord, on 19/7/2024, you said we could direct the, my lord, petitioner to deposit 20% of money.
Yes, yes.
20% has been deposited.
Deposited.
That has not been released by the CDM, my lord. That may be directed.
So it is pointed out by Learned Counsel, Mr. Saikia, that by the order dated 19/7/2024, while issuing notice on the revision, the petitioner was directed to deposit 20% of the fine amount before the Learned Trial Court, that is Learned CJM Sipsagar, and the same was done so. Full stop. It is prayed that they may be allowed to. The Learned Court may release that said amount to the complainant. The prayer is allowed. The Learned Court of the Learned CJM Sipsagar, within bracket, the trial court may allow the complainant to receive the said amount, 20%. At least that much you can. And what about this? It will remain in admission or hearing? Should I admit it? No, not admitted. Are the records come? Actually, the original records can come. So the original TCR. TCR would be necessary, no? TCR is not come. TCR has to be called for. In that case, how about we can admit actually? Admit. People have apprehension also. That is also justified that it will not reach. And that you are not remediless. Suppose in a suitable case, on a hearing day also 26 matter, no, I cannot guarantee. You cannot guarantee. Even late 25 matter, but 24 matter might reach in the normal course because many old matters sometimes are not taken up for hearing. And if suppose it is not reaching despite being listed, we can always upgrade it and fix it on 22nd. The call for the original TCR of
Lordship, I apologize.
no, you call for the we were fixing it. CCR is also not come.
Yes, Your Lordship, we have also not received instructions from the client.
Mm.
So it would be preferable.
I would suggest try and settle it. These things are always, they can be compounded.
Oh.
Try it, settle it. Check criminal aspect, only one aspect. These are actually
Yes, Your Lordship.
the system will be more than happy if people settle check bouncing cases. It's posing such load for the system, as you know. So anyway, we'll revisit it. Call for the original TCR of both the appellate and trial court records we can call of NI case number 55 of 2017 on the learned CGM and criminal appeal number 31 of 2018 from the court of the learned CGM, because both the records we are calling from the trial court because the appellate court will send back the record. Learned CGM. Criminal appeal number so. Post up. He is saying that matter be remain at admission stage only. I was thinking that you can admit it, but it should not prejudice anyone of you.
Mr. Lordship,
Because everything is not possible to dispose of admission stage.
Yes.
Some, ideally this is actually not a second appeal, but a revision against conviction actually should be heard. It should be at the stage of hearing. The matters, the revision is admitted for hearing, full stop. Don't worry. It's not, you're not remediless. The matter has to be heard, that's all. We can upgrade it if necessary, if it is not reaching. Admitted for hearing, list the matter on. Now you work out a date. Hopefully, now since the record has not come, you take that date accordingly. We were thinking of 12th May. 12th May. But will the record come? Sipsagar, no? Due vacation is there. It may come. It can come. TCR, original TCR. What? Yeah, that is, they have paid the amount. They have paid the amount, it seems, 20%. Still you try and deposit it. You release.
The CGM is not releasing it because there is no direction from this amount.
No, I have given that direction. That you should receive.
Obliged.
List on 12.
Lordship, in item number 22 and 23, Lordship, I appears for the petitioner, only my name may be reflected, Lordship.
Okay, we
I
have
was on legs in the other.
fix.
Yes, Lordship, it's okay.
No problem.
Only my name may be reflected.
Your
Because the
good name-
status,
Good
H.
name,
Agarwal.
H. Agarwal.
Because only, anyway, the status report was called for. It is not on, they have not bring the report. 22, 23, excise as well.
Excise.
And said that the.
I asked one thing, that any record, because otherwise we will lose time till the next date. Any record to be called for also.
Status report from the excise, Lordship.
H. Agarwal, Learned Counsel. And status report as called for, not yet received. Issue reminder for the status report of so and so.
Obliged.
Pintas. Unto. Nine, this was for stay of the operation. Dispose of all. The 20% deposit করলে না এখন no problem. Press করা নাই.
25.
Yes, Your Lordship. Lordship, we have to obtain instruction, Lordship, regarding payment of maintenance, Lordship.
The maintenance matter.
Yes, Lordship.
DB matter, then I can take up now. Otherwise, it will, family court, now it goes to division bench.
They have selling the order for the learning sessions.
Yes.
What instruction they will collect? They have move the petition, selling the order of the session, because the session
Yes, yes.
increase.
True,
from
you are-
3,000 to 8,000. Sum and substance of this case is.
Sir has a point, yes, that's
My
true. Any instructions may be necessary in any matter, but still, basically, we are looking at the revision on the basis of the record, right? Yes. And she is the wife. She is the wife.
I am for the wife.
Wife, yes.
Wife. My lord, the maintenance was given to the court time ago. But that was not, does not meet her expenditure. Because no house was provided to her. So she filed an appeal before the landed session does, my lord. And the landed session was finished. And indeed the rupees from 4,000 to 8,000. Because the petitioner, he himself is drawing rupees more than 80,000.
No.
Research allowances in his service. And they have selling the order of the session does, on the ground that the, according to the document of the appeals court, whereas that doesn't in favor of this respondent, why?
So what do you, sir, what shall we do then? They have to start the hearing. I'm ready to take if they argue.
For last 2 years, case is pending and not a single penny is paid by them.
We have to dispose.
Even, my lord, can you see the order passed by the High Court? The first order.
Yes, yes, I've seen
Order
that. Yes.
that you must continue the payment of the maintenance.
Yes. Your payment has to be made. You know, what is he doing? Are you in a position to tell? What is it? What job is he doing? Is he doing a job, petitioner?
Yes, Lordship.
Where is he working? Kindly.
Money going about 80,000 plus other allowances, my lord. You know, it is your position, my lord. There is nothing wrong in that order, my lord.
Can you do it? Can you argue the case today?
No, Lordship, today, my senior is out of station, Lordship. He's adjourned for today.
Mr. Hussain,
Yes, Lordship.
I can take your argument, but it's better they start.
My lord, day after tomorrow.
Day after tomorrow, it's risky because we don't know what matters will come.
My lord.
But I don't know what matters will come on the last day. It will be slightly risky, but I can fix it. I can fix it since it's a maintenance matter of a wife. We can fix it, but no guarantee whether we'll be able to. Depends. So far, we have not fixed many matters. So far, we have fixed only 5-6 matters.
Only my humble prayer, they should have directed to pay the maintenance as directed by the High Court. I could have asked them to continue the payment, but not a single party has to be paid by them. In the quantum, my lord. That observation may be, my lord, that and they may be directed to release that, my lord, area. Not a party has been paid to that woman, a very destitute woman.
Anyway, so kindly day after kindly fix a date after vacation or whatever, and on that day, please tell your senior. Do the matter and finish it because it's pending for 24. I'll areas.
Yes, as per the order of the High Court itself. The first order of the High Court mechanism machine, man.
I've seen.
Who was not inclined to stay the proceedings of the order of the landed session judge.
Achha, it was on the appearance of the sole respondent. The interim prayer was to be considered on appearance of the sole respondent. Your good name, please?
M. Alam Lordship.
M. Alam, Learned Counsel, appearing on behalf of the petitioner and leading counsel, on behalf of the leading counsel, MK Hussain, submits that the said leading counsel is outstation and seeks another date for the matter, full stop. Mr. R.C. Sakia, Learned Counsel, appearing for the respondent number. There's no private, there's only one respondent. For state of Assam, it's also not necessary actually. For the respondent slash wife submits that maintenance amount directed was only rupees 4,000, and arrears are also pending, and drawing attention to the last order dated 5/9/2024. It is submitted that there is no order of stay, full stop. So actually, what should we do? There's no order of stay. It was to be considered after your appearance. Can they pay? I don't know whether he'll be in a position to submit on that. The order can be stayed till the next date, subject to payment of 2,000. 2,000, or it remains like this.
In the meantime, shall comply with the direct sanction.
Yeah, because there was no stay. There was no stay. So let it remain like that. We'll dispose it of.
But they should continue. They did not even comply with this order by the High Court, on a pass on the High Court. And there is no, they did not also file any petition that he is not in a position. He is going now rupees more than 1 lakh, which is land salary. It is it.
No, it was 8,000 was reduced to 4,000.
Now, from 8,000, it was increased to 8,000. From 4,000 to 8,000, what is session also? One of the application.
I see.
And that order they have one of challenge. And there is no statement to that order. They may take the adjournment, but this order should be complied with it. Or whether on the High Court.
Upon perusing the case record, I find that the learned court in the DV proceeding had granted monthly maintenance of rupees 4,000, which was taken up in appeal by the wife/aggrieved person, and by the impugned appellate judgment and order dated 1/7/2024. The same was increased to rupees 8,000. 3,000, I think he can pay. I think he can pay 3,000. So the matter can be stayed till the next date, subject to the condition that he will pay 3,000. Otherwise, he'll have to pay the whole amount if it is not stayed. He'll be liable to pay.
Let it then pay the area as per order of the learned magistrate.
Anyway, kindly work out a date. Please work out a date with sir. Please work out a date. Endeavor would be made to dispose of the matter. To conduct the hearing on the next date and dispose of the revision. Then we can take a call completely. List on. Seven five, okay, 7/5 at 2 p.m. 2 p.m. 7/5 at 2 p.m. No maintenance matters. These should be priority one.
Because there is no stay.
There's full stop.
There is no stay.
The petitioner, the pendency of the petitioner is at liberty to continue making the payments, as no order regarding stay has been passed as on today, including arrears thereof. On 7th May, 2 p.m. You can dispose it of. Hearing day, you can dispose it of.
This matter
multiple cases were filed. So ultimately, 3 or 4 cases have been stayed by this Honorable High Court. Talks are going on, Lordship. He actually wants a permanent alimony.
Arising out of matrimonial dispute,
Matrimonial dispute.
multiple cases.
In fact, this FIR has been filed after filing of the DV case.
DV case.
DV case, domestic violence case.
Mediation has already been paid.
Mediation is failed.
And all
You are seeking quashing of this matter.
A question. Lordship, the talks have been hanging on with some small issues.
Yes.
I hope that it will be resolved in another 1 month.
Okay,
Otherwise, on the next date, we'll finish the matter.
This is 498A.
498.
Okay, no.
What has happened? The entire incident had taken place from till July 2023 in Bengaluru. Now in July, she comes to Dibrugarh, and for the incident of August 2023, she files a FIR after 9 months of the alleged incident. Therefore, Lordship,
You are seeking quashing of the entire criminal proceedings.
yes,
PRC. No?
PRC case impugn proceedings. And there is as per her statement only, there is another FIR filed in Bangalore also, which is not brought on record. Therefore,
Divorce petition is not there.
yes, we have filed a divorce petition also.
Heard, Mr.
And Arun
V.P.
K.
Bora, learned counsel for the petitioner.
See our case.
And Mr. Your Mr. Sahad, the good.
Yes, sir.
Yes, Sahad. I'll hear you. I'm not just closing. Yes. Yeah.
I have no objection regarding compromise.
Yes.
But my learned brother is stated, but this may be the last chance, because they have already availed of so many chances.
He has said also that next day, if it
Yes, I have already said. And it is hanging on a little thread. I hope it will be done.
fair enough.
Uh-huh.
The learned, the petitioner has filed the instant proceeding seeking quashing of the criminal proceeding pertaining to PRC number 528 of 2024 under section 498 IPC arising out of Dibrugarh PS case number 165 of 2024. Full stop. Mr. Bora, the learned counsel submits that multiple litigations are pending between the informant and the petitioner who were married and now and one divorce proceeding is also pending. It is submitted that efforts are on to arrive at some settlement regarding the multiple litigations. And if the same is not done, perhaps this matter can be taken up for hearing on the next date. Mr. Sahad, learned counsel for the respondent informant, submits that on principle he does not object to effort at settlement, but the matter has been also pending for a while. And earlier mediation had also failed. It's fair enough. Are we ready with the records? Any records will be necessary. Otherwise will waste time. I don't see any record. That's records.
TCR.
Only need it. Don't you think we'll need some record?
The record will, the TCR would be required.
In the meantime, we'll save some time, otherwise next date again. Do it. In the meantime, call for the scan TCR of that PRC numbers also, including case diary, charge sheet, and other relevant documents if any. It is not, even a trial has not started.
Trial has not started. It has been stayed.
It has already begun. Charge has been framed.
No, charge has not been.
Posted for prosecution evidence.
I don't know, sorry.
No, I think that, no, there is an interim order. There is an interim order, sir. There is an interim order. Let me see what is the, no, yes. 9/5/2025. Till then it was going on. After 9/5 it is not there. It's said. While order dated 9/5/2025, further proceedings in the aforesaid case was stayed. Full stop. The interim order shall have to continue till the next date of listing. Kindly work out a date.
June not right now, Dada. June first week.
Stick of May maybe, or as per, I don't say anything.
Yeah.
As per your convenience.
After 15 May, any date.
Mutual convenience.
What do you get?
Yes.
As convenient to your lordship.
One sentence may be added.
Yes.
Because they have already required
Hmm.
for settlement.
Mhm.
If that is possible within that period, that is to be a factor. It is
Yes, actually, I've indicated, actually.
Ah,
Yes, that
your
it will be
lordship
taken
has
up for him.
already indicated.
Yes, I've indicated. So, motion day or hearing day will take up
Hearing
28 May. Or
deeply
28
obliged.
so, 28 May
Deeply.
is, I think, Thursday.
Yeah.
28 May.
Deeply obliged.
28 May. Revision কিবা আছে নেকি? Supplement. কিবা আছে নাই? Yeah.
What is it?
But admission, দেখা যাবে কাগজ করাটা মনে হয়।
May it please your lordship. Well, this criminal petition has been filed for quashing of an FIR. On the last occasion, your lordship has called for the case diary along with the CA's report. The whole contention of the case revolves around the CA report, which they have found a disproportionate assets of 3%, 15%, or 15%. And this the Honorable Supreme Court in a number of cases when the discrepancy is
10%.
10% or around, not exactly 10%. If it is minimal, then it can be quashed.
Here it is 3%.
No, 15%. 15%. And we have given our explanation. You'll have your time, sir. So please take it, sir.
I have received the case diary, reporting also.
Just a minute.
I have done so in all this.
Just a minute.
My lord, the FIR console, photo,
26. First time.
Okay. Shall we take up the matter?
Yeah, I have found
15.3%.
FIR has been registered after 11 years, my lord.
After 11 years.
And the check period is your lordship, can you look into the FIR at page 28?
Just entering, Mr. Botak, just doing a little bit of. I'll not.
Page
because-
28. Because
So we take it
ultimately-
or will not keep it part hard.
Yes.
That's why just
Your lordship, just look at the FIR at page 28.
28.
This FIR was lodged on 29th of January 2025. There's a history behind it because I came before this honorable court in a contempt proceeding out for implementation of the orders of the court. Only then this FIR has been vindictively lost. Your lordship will find, with reference to the subject cited above, I have the honor to inform you that some timber shop owners of Gauhati city lodged a complaint at this director on 16/12/2013, where it was alleged that Sri so-and-so, the land forester, and Sri so-and-so, the petitioner, the then Foreign Range Officer, both were posted at BIO Assam Gauhati at the time, were involved in illegal collection of money in every month from almost all the timber shop owners of Gauhati in the name of managing police personnel of BIO. Moreover, these two officers started demanding money per month in the name of the managing the insurgents in charge of BIO, that is the then additional DGP of BIO Assam Gauhati. It was also alleged that these two officials had threatened the timber businesses to register criminal case against them in case of non-payment of the demanded money. Accordingly, a preliminary inquiry in this regard was initiated at this directorate by P number 40/2013, that your lordship will take note. It was of 2013. Later on, based on the approval of the government by memo number so-and-so dated 23/7/2014, the PE was converted into regular inquiry by RE number 16/8/2014 on 25/8/2014. In course of the inquiry of the above noted RE, few timber shop owners were called for examination, where one timber shop owner, namely Shri Pranab Jyoti Bhuya, appeared before the EO and stated that he was doing timber business during the period when the aforesaid suspect officers were serving at BIO Assam. He also stated that he had paid ₹5,000 every month to the SOs during that period for smooth functioning of his business. He further informed that he ceased to do timber business since November 2014. During inquiry, the house of the suspect official, Sri so-and-so was evaluated by the executive engineer PWD Gauhati building number 2, Dispur, Gauhati 6. The evaluation report was received from the Gauhati engineer building division number 2, Dispur, Gauhati, white letter number dated 26/2/2016. The total cost of the building was found to be rupees 30,05,812 only. The house of the suspect officer, Sri So-and-so, is a 3-story building located at Nayanpur, Ganeshguri, Chareli, Gauhati. Sri So-and-so had obtained permission from the ground floor for the GMDA, white memo number 12/9/1994. It was in 1994 for first floor, 17/2/2005, and for the second floor on 15/10/2012. Further, the movable and immovable properties acquired by the SO so-and-so were rechecked and re-verified, apart from his submitted statement of assets and liability. We submitted the assets and liabilities for the check period in 2016. The assets and liabilities of the suspect officers were analyzed by an empaneled chartered accountant of this directorate. That's why your lordship has called for the report of the CA. On the last occasion, it was not there. Report of the analysis of assets and liabilities submitted by the empaneled CA in respect of so-and-so has established that the disproportionate assets in respect of suspect official, so-and-so, the then forest range officer, Assam, Gauhati, for the check period. Now, your lordship will see. 1/2/1989 to 13/6/2014 is rupees 24 lakh so-and-so, which is 15.3% above his income. This 10% of the Honorable Supreme Court, your lordship knows the judgment. But in some cases,
I've forgotten the name of the judgment.
yes,
But
we'll replace the judgment. That's so citation today. It was also discovered how it has to be evaluated. That was the first judgment when it was discussed the entire procedure. It is, my lord, 1977 1 SCC 816. Extra copy, sir. I'm furnishing an extra copy.
this Botakur, will you be able to do it today, or you don't want to do it today? Because I don't want to waste his effort also.
My lord,
Sorry, sir.
But
regarding other aspect, my lord, I will have to go for the city, my lord, regarding that here the as per report, my lord, where the expenditure is an amount of rupees so more than his own source of income, which results in 15.30% disproportionate.
we are not disputing it. Only we have an explanation for that 15.3%. We have given our assets and liabilities. For 15.30%, they have not considered the wife's income. And your lordship, what has done? Well, at the moment on the last occasion, when I pointed out that the CA report is not there and this discrepancy is there, during the pendency of this case, my lord, they again raided my house on
11/2.
11/2. They have raided my house, and this time I have kept 2 lakhs for my daughter's marriage. They have taken away that 2 lakh rupees. What is this, my lord? I came challenging the FIR on this basis of this FIR. Since I have come for quashing, they again raided my house in 2026 in the month of February and taken away 2 lakhs rupees. That's why they want to delay this matter. Because they did not have any evidence at that particular point of time. Now they are trying to...
It will not be delayed because otherwise we have only 2 days, right?
Yes, ma'am.
Yeah. So just planning it. Suppose we have 2 days, so we don't have after vacation. I mean, if it gets parted, because I'm likely to be outstation after 2 weeks at least, immediately after reopening. So it will remain stuck. I think if you are ready, suppose we can complete the hearing today, fine. Otherwise, if not, then I would propose that immediately after reopening, you fix it and get it done. No, not me. It's not parted. That's why. After doing a substantive part of the argument, the council's effort is wasted.
Well, subject to your lordship's convenience.
No.
Not my only thing is that, my lord,
I'm also thinking of your convenience because you make your...
only thing is that last day on good faith, my lord, I did not sought for a direction not to take coercive action. Just because I, as an officer of the court, I believe that they will produce the record. They go to my house and seize, to my daughter's marriage is there, they go and seize the 2 lakh cash. My lord, in a retired employee's office, if you have 2 lakhs and if you take away the 2 lakhs before the marriage, my lord, and they look at their conduct. They have not even apprised this honorable court that during the pendency of this case, we have again raided the house and recovered 2 lakhs rupees from his...
That's not good.
Yeah. Your lordship will fix it on 30th, subject to your 30th of April.
Yes.
But only thing is that they should not take any coercive action during this period when they seek time for hearing of this case, my lord. That your lordship will make it clear, because the last time when your lordship did not give any direction, they say they went and raided my house, my lord.
Today, because I did not get time to go for the city, so whether
That is his contention.
What are the
Must be,
details
must
in the
be,
safety- what
must
are
be
the
correct
authorities
anyway.
of the IO member? So I will have to.
Lord Senior Counsel, Vidhi Kumar, additional PP, report full stop. The case diary has been received along and as full stop. A report of the chartered accountant of the department was also called for, and the same is also stated to be received. Full stop. The learned additional PP submits that he could not go through, he could not get the time, he did not get the time to go through the records and submits that it will be convenient for him if the hearing is taken up on another date. Full stop. The learned senior counsel submits that during the pendency of this petition, his house was raided in connection with the same
11,
case.
same case. 11-2, they have taken away cash
The
and
learned-
some gold
during the
ornaments. Gold
pendency of
ornaments they
this
have given in
petition-
Jimma, the case they have retained.
Pendency of this petition. Full stop.
Regarding those aspects, I will have to give the instruction.
No,
last word. During the pendency of this petition, the house of the petitioner was again raided and rupees 2 lakh in cash, which was kept for his daughter's wedding, was taken away. Full stop.
Along with gold ornaments and gold coins, those were
Along
returned.
with some gold ornaments, etc. Full stop. The the other additional people submit that he shall take instructions regarding the same. No? That he will have to take instructions regarding the same. The said instructions may be taken. Full stop. The investigation is completed.
No, investigation is going.
Still going on. Full stop. The trial court has to be informed. The trial court has to be kept in
Your
the
Lordship
loop.
will kindly see these two documents. You can kindly do it.
Trial court has to be kept in the loop. That is important.
The first is the order directing to conduct the charge and seizure procedure. The second is the Jimma given of the those articles except the 2 lakhs rupees. Seizure list we don't have the copy, but the Jimma number we have in the next page, madam. And all these coins and all were given during my ring ceremony of my daughter by her by our relatives, madam.
These were given in Jimma.
These were given.
Dated 11/2/26.
11.
11/2/26.
Yeah, must be the same one.
Yes, yes. That's why I have said, my lord,
It's the same one. It's the
as
same
an
one.
officer of the court, we have to make a frank and fair disclosure before this.
The learned counsel, learned additional PP, referring to the case diary, now submits that the said search is reflected in the case diary as having taken place on 11/2/2026. Recently, that means.
Last date कितने है सर? Last date कितने है सर? Case 2. Okay, sir. Last word.
Full stop. The full stop. So instruction part is there. However, the
Going for the city one, because that is regarding.
Yes, yes.
seizure list and
Yes, yes.
clearly they are.
However, as the learned counsel has submitted that the said aforesaid search and seizure was done vindictively, full stop. The learned additional PP shall nevertheless take instructions regarding the same, full stop. Further, full stop, as the investigation is not stayed, therefore, the IO would be at liberty to conduct the same. However, the petitioner shall not be subjected to any undue harassment. Full stop. That's all. We can make it.
But your lordship will use the word coercive. Otherwise, they will again, for the sake of reading, they will again go and disturb me.
And you know, because coercive action
My lord-
investigation is taken place because he's on bail, right?
Yes, we are on bail. That's why we did not sought for any
No,
coercive.
coercive
The
action
last,
will have wider meaning. Unnecessary harassment, undue and unnecessary harassment.
because your lordship will recall, on 27th of January, this matter was listed and raid
follow-
was conducted on 11.
And steps of and necessary steps of investigation taken during till the next date shall be brought to the notice of the learned trial court as per the criminal procedure governing the process, criminal procedure.
Well, your lordship will make it without the leave of this court, my lord, because they can make a matter.
No, because there is no stay.
No, well,
Because
that's
there-
why we didn't short for stay was that because
no-
we are on bail.
The stay of investigation is a
only
very
on the last one when it
no,
was-
no, because stay Niharika infrastructure, the stay of investigation is the threshold is very high, you know.
No,
The
we are not
threshold is
saying
very
for
high.
stay for the, but no coercive action because this unnecessary, my lord,
No,
going
that
and
is-
raiding and threatening us
No,
and
that-
taking away
that's
the.
what I'm saying. I
my
get your
doc-
point, Mr. Akbar. The because it will create a mess for the situation and also the IO. Because you know the coercive action and then he has to come for clarification. Whether it means investigation, we should not pass confusing orders, you know, as far as possible. So inadvertently it's different, but I think this should be sufficient for
Yes.
for your
But,
purpose. For your purpose.
but one-
When a court,
Yes.
any courts,
Yes, yes.
any court says that.
Now he
especially,
is cautious, my lord.
Constitutional court says that you know undue unnecessary harassment.
Yes.
They will understand, right?
one more-
And we can fix it on 30th.
For final disposal in the admission stage.
We can fix it for this thing, but it's a hearing day. You know, actually, ideally on hearing day, we should give priority to hearing matters.
But
We can have
admission-
first half hearing. Actually, I see it that way. We should have hearing in the first half when we are fresh, and second half we should have for other matters. But usually it's the other way around, and hearing, some hearing should take place on hearing day,
But 30th is a Thursday only.
Thursday. We
Yes.
can fix it, no doubt.
Yes, yes.
Depends on you know what hearings are done, not
Yes,
done.
yes.
Are you agreeable to that? What
Yes.
or you want another date?
7th of May. In the meantime, I will try to get detailed instruction.
Well, I have no objection, my learned friend, sir. But only thing is that effort should be made to dispose of it, not unnecessarily keeping it
Yes.
pending. Does after retirement also, my lord, for all these years, my lord, the
Because,
show is hanging over my head.
The learned senior counsel submits that as the petitioner is presently retired, he prays for, he submits that, he prays that on the next date, an effort may be made to dispose of the matter. List on 7.5.
We are deeply obliged, my lord.
Admission call.
We are deeply obliged.
What else? Brought us.
May it please your lordship.
Yes, ma'am.
Quashing of a DV Act proceeding.
DB Act.
Yes, lordship. So I want a disposal at admission stage. If your lordship wants to conclude the order matters first, then this may be taken as last matter, lordship.
Quashing of DV matter, right?
Yes, lordship. Notice was issued and stay granted by this court, lordship. The husband, mother-in-law, father-in-law, and sister-in-law, lordship.
You are for legal aid counsel? For the wife? Maintainability. There also we can see. If that, should I take up now or order matters? 3 order matters are there.
Yes,
Should I do
lordship.
it?
And lordship.
Because as I said, no, I would not like to keep it part third, any hearing, because holiday. Then probably I'll be asked for next week. And then it will delay you and it remains stuck.
Lordship can
So either
dispose
we
it up
complete
only.
it and I can reserve it, not necessary to dictate it here, but
Lordship.
we should complete the hearing. And tomorrow there's no chance. Day after tomorrow. Okay, orders can proceed. Order matters, let us finish. I don't know what order matters are there.
61, timing at 50.
Timing is in. Are no break will organize it.
May I please your lordship? The second application, lordship. First one after the case has been surseated. Earlier was earlier one was rejected, Lordship, before the search sheet was filed.
Okay.
Lordship will find
Never
the
mind. Page.
FIR on page 14
Hmm.
and the type copy on page 10, Lordship. This is the
Yes.
may I read, Lordship?
No, I understood from it is written also here.
Yes.
His father was assaulted. Huh?
Yes,
And he died, later he
Yes,
died.
yes. Here in the FIR, Lordship, 3 persons are named. Present petitioner is Mainul Islam and other 2 persons, Roni Islam and Rohan Islam, are the son of the present petitioner. And Lordship, first contention in the FIR is that, Lordship, the incident took place on 23/7/2025. Clearly specified in the first para of the FIR, the incident took place on 23/7/2025. Then the FIR was lodged on 29/7/2025. 6 days later,
So anyway,
after the incident took place.
it's the murder case has been registered. Yes.
Now the TCR has came, Lordship.
Trial has started.
Lordship,
Appearance.
My appearance. He is the absconder in the search sheet, my lord.
Okay.
My question of
submission has been filed.
here, during the investigation, he is not co-party with the investigation matter. And 2 of these son matters, they were arrested and released from jail. Yes. Here, he was from the date of war, he is absconding and search also made. And he was found absent matter. That's why the absconder search sheet was submitted matter. Hereafter, matter on 26/2/2026 matter, NBW issued matter. Considering the nature of the offense matter and as he is not appeared matter, and 26/2/2026 NBW issued matter. And next that is fixed on 8/5/2026 for appearance. Appearance. And Lordship may kindly please the matter. Eyewitness, some eyewitnesses also there, madam, how they have.
On merits.
Assaulted matter and killed the matter, person matter. And PM report also shows that injury in chest mind, that is also there. And as the charge is not yet them minor, my he is always at liberty to surrender, but not the bail at this stage minor. Here, as it is the anticipatory bail file minor, and earlier also it was rejected minor.
Right.
And here also no new grounds, and at this stage minor.
Okay, that is your
I have got
contention.
some objection matter as it is involved 103 of the minor hearing. I mean, one witness matter, I witness.
May I submit, Lordship?
Yes.
Lordship, I had a chance to look into the TCR, Lordship.
Why you have not seen the TCR?
I have seen the TCR. Lordship, I have got a chance to have a glimpse of the TCR, Lordship. The eyewitness, as stated by the prosecution, is one Amar Karmakar. That may, Lordship, that para may be, if Lordship goes through the para, in the Amar Karmakar has also, in the last part of his statement, he has categorically stated that only Rohan Ahmed and Roni Ahmed were present. And one more statement, Lordship, Tina Khoria. In her statement also, she has categorically stated, Lordship, that only the son of the present petitioner was present and they have beaten the deceased, Lordship.
No, in Aman Paran's statement, minor, his statement, his involvement is there, minor.
You can read. Do you have the statement?
No, man.
Not just that.
In the last para, in the last part, he has clarified. In the beginning, although he took all 3 names, but in the last part, he has clarified, Lordship.
Pelai, Bogarai.
In the last part, Lordship.
That's true.
Lordship has seen, Lordship.
Yeah.
And Tina Khoria also, Lordship.
All right.
And total 10 cases in the search of matter.
You complete your submissions?
Mine.
Lordship, and if Lordship comes to page 29, Lordship, of my bail petition, Lordship, the forensic has submitted the report, Lordship, and it has been stated as natural death, Lordship. On page-
Natural death?
Page 29, Lordship. It might be available in the TCR also, Lordship. We have obtained the certified copy.
No, that was due to synopsis. This will be from the PM report. PM report says natural death.
No, forensic.
PM report not complete, my lord. They have to just send for, my lord, etc. send for, my lord,
That was-
FSL.
FSL.
And FSL report found that it was no poison. No poison. Thereafter, final opinion was given, my lord.
That
And-
was due to synopsis as a result of chronic coronary insufficiency.
My lord, that is.
Natural death.
My lord,
Natural
that is there.
Natural death. This is the final opinion.
Final opinion.
In that case, the homicide may not
But
come actually.
And Lordship, there was delay.
But this is
In-
there, it's here also.
my lord.
Forensic. Anyway,
In-
I'll see it
My lord,
properly.
my lord.
Part-
From the witness, we are resting on the.
But if it's a natural death, then yeah, then it may be might have to be a little different.
And Lord,
Also, otherwise, it may be assault.
My lord.
The assault sections may come.
My lord.
Mm.
and Lordship, the
But
present.
the allegation is sorry, just a minute. The allegation is about Bogarai with the fist and all that,
My lord, my lord.
not weapons.
Not weapon. And my lord.
But a
PM
person may die due to that also.
My lord, in the PM report of.
Spleen is injured.
Injury in the chest.
Injury in
It
the
also
chest.
corroborated from the evidence of the eyewitness.
Yeah, you complete your submission.
Lordship, one more thing, Lordship. In the FIR itself, Lordship, the complainant has stated, Lordship, that they have a land dispute, Lordship.
That is different thing, and this.
They all-
For that, he has no right to kill one person.
No.
That is.
Yeah. Though.
If I am not wrong, Lordship, in the statement of the eyewitness has stated, Lordship, in the statement also, in the later part, he has clarified that only two sons, his sons, were there when the incident took place, not the present petitioner, Lordship. That is my submission, Lordship. And Tina Khoria also, they categorically stated that only two sons were there. In the only one eyewitness is there, and other Tina Khoria, Lordship. And other has relied upon their statement, and the complainant has filed the FIR, Lordship.
Anyway, so it was it's the Medi Land Council and the Sarma. It was our earlier bail petition was rejected on 26/9/2025 in AB 2320 of 2025. Para 234. Good stuff. The Learned Council's drawing attention to the relevant document
Again, same.
regarding opinion of death points out that it is stated therein about natural death. It is submitted that in the statements of eyewitnesses, he has stated about the presence of sons of the petitioner rather than the petition. It is also submitted that the informant himself has mentioned about land dispute in the FIR. On the other hand, the learned additional PP submits that the petitioner was absconding since the day of the incident, and despite search, he could not be found, and he was shown as absconder in the charge sheet. The learned court below has issued NPWA against him. The eyewitnesses have implicated him. Full stop. Charge has not been framed and witnesses not examined, and learned additional CP objects to grant of bail at this stage in this subsequent petition. I'll just have a look at
Here,
it.
PM report has, my lord, page 22 of their petition, my lord. Here, ounce, my lord. Their petition, my lord. That's one.
Page 22.
Page 22 of their petition, my lord. There's an example PM report, my lord. External appearance, my lord. Ounce,
Ounce?
my lord. Ounce, position and character, my lord.
Ounce.
Wounds position and
Sorry.
Ounce.
My lord. The middle of the chest.
My lord.
No, person can die due to that also, but it's a medical opinion.
The detail of the statement.
Anyway, that's why I'll have a look at it.
One more, my submission, Lordship, that regarding the delay of lodging the FIR, which is incident took place on 23/7/2025 and
There are matter of trial, my lord. How we-
Lost on-
It is submitted that there is also delay in lodging of the FIR. We will not go too much into merits because it's a subsequent bail petition, right? Rightly or wrongly, earlier one was rejected. Just give me a 2-minute break, then I'll come back.
Lordship.
This is done. So that for orders.
Right.
This is the, and the IA, same. Notice upon respond number 2 was taken, but service report is awaited. The prosecution shall take instructions.
Right.
When do you want it, ma'am?
After vacation, is it?
After vacation. After, yes, it will be after vacation only.
First week of May, but
First week of May. You can fix it on, how about 8 May? 8 May?
plus.
What is your name?
Ah,
I plead the Lordship. Lordship, in this case, Lordship, as per the office note, Lordship, TCR is not come. And Lordship,
this was also admitted, but
Lordship, though Lordship, in this case, Lordship, in
7 years.
in IA, I have annexed all the evidences, Lordship. There is a prima facie case, Lordship, conviction is not sustainable.
So,
Lordship, here conviction has been given 7 years under sections 304 part 2 IPC, Lordship.
scan the record is not,
Not received, not.
not scan, it will be original.
Original, yes.
Anyway, take it up after.
Lordship, because Lordship, I have annexed, Lordship, all the evidences, Lordship. Lordship is Peru's, Lordship.
Because how many witnesses are there?
Lordship, there is a 9 witness.
We have to see it prima facie.
Lordship, there is no Lordship. I am Lordship here. Lordship case is that Lordship on 25/6 that incident was took place, and that thereafter Lordship they are taken into hospitals, and subsequently he died, Lordship. But Lordship, in this record, Lordship, there is no medical report or any hospitalization documents has been produced before this trial court.
Record, there are DWs also.
Record also not.
Record also. Prima facie, otherwise it's a fixed sentence, 7 years. A little bit as that aspect, that it's a fixed sentence. And secondly, a little bit also on the prima facie merits. You know, we need to see. I think it will be best after the vacation. On real.
Lordship, one more thing, Lordship, just type.
He's been in custody since when?
Yes, 116. No, Lordship, on 16/1. Before Lordship, before the trial, Lordship, without any warrant, the trial court has taken into custody, Lordship. That part also there, Lordship.
Because today, let the record come. He has annexed, but still the main appeal to order to passport. This also you have taken steps on the notice on the respond number 2.
Yes.
Informant.
Yes, registered post as well as
essential actually. It appears that the informant has been implemented as respond number 2, and the appellant has taken steps upon her, but service report is awaited. Still awaited. Let me see, office note. Service report is awaited. You can take instructions if necessary. Prosecution
I
can
think
take
Lordship,
instructions.
that instructions may be taken from the registry, Lordship, not my learned friend.
Not from. No, TCR.
No. TCR as well as Lordship state.
TCR too they will, but
as well as Lordship state.
R2, respond number 2, they will take.
Yes, Lordship, registry.
Then I will not say the prosecution will not, the instructions may be taken through registry regarding service upon respond number 2. Oh, yes. It was second central thing. The issue reminder for the original TCR of sessions case number 194 of 2012 from the Court of the Learned, additional session judge Dhubri. I had to get
Lordship, one sentence, if Lordship possible. After receiving, Lordship, if possible, Lordship, paper book may be prepared, Lordship.
Paper book, definitely.
Lordship.
Paper book, I always prefer paper book, but sometimes single bench they don't. But I personally always prefer. And I think we should invest more in our paper book divisions
Lordship.
of both civil also.
Yes,
it's very helpful. Second appeals and all.
That's why Lordship, that order.
Registry may prepare a paper book in sufficient sets after receipt of the TCR.
Lordship, and Lordship, one more thing, Lordship, regarding the service, Lordship, postal track maybe.
Yeah, the registry shall verify the service from postal tracking. It is not essential. The IA to similar order.
Lordship.
We'll take up the after the receipt of records, irrespective of the paperwork, we can take it up. You work out a date.
Lordship, want 27 or 28 in this month, Lordship, possible? Any date before this month, Lordship, if possible.
Let it
Has-
be in the
নহয় নাই ভাই আৰু টাইম লোৱা একো নাই টাইম ল'বা তুমি একো নাই ল'বা আহক আৰু
8 May or 11th May. 8 or 11 May. 8 May. There's one hearing also. No?
May I please, Your Lordship, I'm sorry for interrupting.
No
With regard to item 48, despite concern not given, the DLSA have mentioned, now I have no objection since they have mentioned. But I want to,
Yeah, but
Yes.
I know they said it. You're for the petitioner.
yes, I'm for the petitioner.
No, the opposite party,
Lordship.
counsel, she said that
Yes,
they have
yes.
objected. So
Yes,
I have
yes.
kept it open. Actually.
Lordship, yes, I just want to make one request, Lordship. Just one submission that on 20th of this month, the petitioner has to appear on the lower court. So if the observation can be made that he seek adjournment on that day, can make it.
That is open for them, they can adjourn.
মই পাহৰি গলো নহয় কি লিখিলো কোনে বা লৈছিল
If that can be recorded.
কেবি লৈছিল I have not signed any order today. অলপ আপুনি লিখি ল'ব না এইটো। Learned counsel for the petitioner while not objecting to the prayer for adjournment today sought for by the learned counsel for the private respondent submits, however, that the next date before the learned court below is on 20th of
Yes.
on 20th of this month. Full stop. It is open to the petitioner to bring the said fact, the fact about pendency of this petition and the adjournment today to the notice of the learned court below on the next date. That will do.
Much obliged.
We have also received case diary also, madam. That may be written on
20th.
And that may be fixed.
I've forgotten the facts of the case. What it was.
Fix on.
It's already fixed.
On 20th will be fixed.
Let's see the video. After from this court.
No, sorry, I mixed up, madam. Sorry, this is what happens when you get. I thought 20th is before the lower court.
Yes, before the lower court.
It's lower. We have
Agree.
also fixed. We have also fixed on 20th.
So
So then it's
do
okay.
Okay.
Then the order is okay. Then it's okay. Case diary is received. কি করবো আপনি? Well, we'll retain it.
No order may be passed, madam. If department, they will-
Okay. Case diary was received.
Yes, there is, that's.
Oh, that's all. We won't say anything. Then we fix it. The date is already fixed now. It's okay for you?
Yes, Lord.
20th April.
Much obliged.
We do the ISL. 20th April. And
Yeah,
you write it
we
down.
have CD receipt.
Case diary receipt fixed on 20th April.
Ma'am.
2026. That was fixed, no? Earlier? Yes. Otherwise, I feel be confused. 20th April.
Obliged.
20 April. Hearing to, will it be possible, Ms. Sultana? We have time for only one matter. I think. At best.
Item 49, my lord.
He's on custody? He's in jail or he's on bail?
There is appeal against acquittal, my lord.
Acquittal.
Acquittal, and my learned friend out for the respondent, my lord.
Take it, appeal against acquittal in a GR case, police case.
Yes, my
In a
lord.
police case. Take it after vacation on a hearing date.
Okay, my lord.
Or you were interested in doing it?
I am ready, my lord, to several deaths are,
Several deaths have gone.
several deaths.
No,
were-
because that matter was, she just accommodated. It's a quashing of a DV matter. So
My lord.
we have, I mean, if I sit till 4:45, your matter may take some half an hour, I think.
Lordship, maintainability issue, my learned friend has raised, so after that I will go, lordship.
Okay.
My lord.
Just
I
wait
will-
for a while. Huh? Just wait for 10 minutes. Kindly, you just wait for 10 minutes. Let's see.
As in the
Maybe
maintainability
possible
issue
also.
was raised, lordship, so learned friend may start first, lordship. so that I can reply.
I think there's some judgment because DV matter actually
Can be
it's
quashed,
like,
Lordship.
huh?
Can be quashed.
Can be quashed, but it
Yes.
has come from a Supreme Court decision, right? Or it has come because there are some decisions of our High Court also.
My learned friend
But
has raised
Supreme
the
Court
issue
decision
of
also come.
maintainability on what ground she has
Yeah,
not
because
disclosed.
it is actually because there are judgments to that effect that the DV has been held to be a civil matter. It is a
Lordship.
one day it will go to
That
the
is Saurabh Kumar Tripathi
Yes.
by Honorable Justice Abhay S. Oka and Ujjwal Bhuiya sir.
Yes, that is a civil matter.
Yes.
One day you will see DV matters going to family court one day,
Lord.
you know, but it has not yet come. So it is basically a civil matter, except for violation of protection order when it becomes criminal liability comes. So since it is tried by magistrate, therefore it comes as a criminal appeal.
Lordship.
29
Lordship.
to the sessions case,
So-
and therefore it comes as a criminal
482.
revision. Except for that nomenclature and the forum, it is for all practical purposes, it is a civil matter. And it has been held so also, except for that violation of protection order. So therefore, in that sense, there may be a quashing, but otherwise it is not a criminal proceeding. This is my basic understanding,
Already
subject to
Supreme-
correction.
Already Supreme Court held that DV matters can be quashed.
Quashed.
The law points were raised that the proceedings under Section 12 of the Domestic Violence Act are predominantly civil in nature. The High Court can exercise its inherent jurisdiction under Section 482 of the CRPC to quash proceedings under the DV Act 2005, but must do so cautiously and only in cases of gross illegality or abuse of process. An application under Section 12 of the DV Act is not equivalent to a complaint under Section 200 of the
Yes,
CRPC.
it's not
These
a
are the
complaint.
points we already discussed.
Yes. Aggrieved person, it's 12 is a complaint, but it's not a complaint within the meaning of that.
My
Complaint in a
learned
criminal
friend
case.
has raised objection on
Yes,
what
now,
basis?
Miss Devi, just I'll come to you. Yes, DV action line.
There shall lie an appeal to the Court of Session within 30 days from the date on which the order made by the magistrate is served on the aggrieved person or the respondent as the case may be whoever is urgent. So here that according to my understanding, it won't come under Section 480. So let's file the appeal under Section 29.
29 to law. 29 of the.
Just, I mean, sorry, madam, this sort of Sukla,
Yes.
this is, there's no earlier decision pertaining to that, before that. Because this is not a recent position of law that for some, in certain situations, DV proceedings can be quashed. It is not a recent position of law. It has been fairly well settled.
2025.
Huh?
19/5/2025.
No, I think it's come before that also. This must be reiteration, one of them. Sort of, but still I'll see. Sort of
Saurabh Kumar Tripathi.
Tripathi.
SHAURABH.
It must be reiteration. If I'm not mistaken, this position has been there for at least 5 years. At least 5 years that it can be quashed. Those quashing petitions, if you see our High Court
I'm
also
with the
database,
latest
you'll get
decisions.
cases, earlier cases also. Anyway, but this
I
must
am
be
with
having
this,
some earlier
latest
decisions also.
decisions that it discussed about under the criminal courts, under the CRPC. Chapter 2 deals with the constitution of criminal courts and offices, the courts of session, judicial magistrate of the first class. That my learned friend has raised that there is an option for appeal, Lordship. That was also taken into consideration in this
Yes.
decision.
This, can you give me the citation of Saurabh Tripathi? If you have.
I have only one copy, Lordship.
A citation.
Citation,
you
Lordship,
have.
that is 2025 AIR SC 2598.
2025 AIR 2025 SC.
2598.
Okay, no problem. Sorry. So now this order is passed by the magistrate.
Yeah.
Magistrate. So according to you, not according to you, as per the law, you think it should be an appeal.
Appeal. When there is a specific provision of this So my, that, my parents said there should be appeal period for the session. Before the court of session. In that suppose also I want to please have judgment lawsuit which was passed by this.
And the aspect of limitation, whether it applies, there is a judgment of our High Court. I think Justice Mehdi has written a long order judgment about whether Section 5 Limitation Act applies to Section 29.
Lordship.
There is a judgment.
But I
have-
am before
have-
your lordship for quashing of the entire proceeding.
So sometimes,
I am not only aggrieved by that order, lordship.
okay, what was there in this decision? And
Pardon number two. It was like, online.
also, I had also written some, this thing. I've forgotten.
had not to sign the order to online.
And so this is okay. Okay. This is your respondent. Yes. What is the impugn order? Let us see the impugn order.
Lordship. Stay already granted in this case, Annexure 5, page 70.
Page 70.
Yes. Before that, I may point out one thing that, Lordship, at the time of filing of the criminal petition, we have not enclosed the Section 12 petition. So that was brought into record by way of an additional affidavit later on.
That's okay.
The relevant portion is page 74.
Mhm.
Page 73, last two paragraphs from there, your lordship can read. In the instant case, whether the respondents have perpetrated domestic violence upon the aggrieved can only be decided after evidence are laid from the source of both sides and the matter is finally adjudicated by the court. Having said that, commission of domestic violence is in itself an illegal act, and I am of the view that the respondent number 1 to 4, against whom a protection order under Section 18 of the PWDV Act is sought for shall not be prejudiced if they are prohibited from committing any acts of domestic violence as envisaged in Section 18 of the said Act. As such, by virtue of Section 18 and Section 23 of the Act, and considering the observations made herein above, I hereby prohibit the respondent number 1 to 4, namely Parvez Alam, Tahir Hussain Ansari, Nasima Begum, and Shamma Parvin, from committing any act of domestic violence, aiding or abetting in the commission of acts of domestic violence, entering the place of employment of the aggrieved person or any other place frequented by the aggrieved person, attempting to communicate in any form whatsoever with the aggrieved person, including personal, oral or written or electronic or telephonic contact, alienating any assets, operating bank lockers or bank accounts used or held or enjoyed by both the parties, jointly by the aggrieved person and the respondent, or singly by the respondent, including her stridhan or any other property held either jointly by the parties or separately by them without the leave of the magistrate, causing violence to the dependents, other relatives, or any person who give the aggrieved person assistance from domestic violence. So this, by this order, my personal bank account was also, I was debarred from operating my personal bank account was, lordship. And thereafter a maintenance was also granted. Moving on, the term domestic violence as defined in Section 3 of the PWDV Act is not merely confined to acts of physical cruelty, but it also includes in its ambit economical abuse from the application of the aggrieved person, and documents filed along with a prima facie case of domestic violence is made out,
Further, the purpose of allowing interim maintenance to the aggrieved person is to provide financial security to the aggrieved person and prevent vagrancy and destitution of the aggrieved person during the period of trial. Upon perusal of the applications and the documents submitted by the aggrieved person, including the affidavit of the assets and liabilities, it prima facie appears that the aggrieved person has no independent source of income of her own, and that the respondent number 1 is a doctor by profession and earns a monthly income of rupees 1,50,000. The aggrieved person has paid for an interim maintenance of rupees 50,000 per month. However, the aggrieved person has not furnished any document to substantiate the fact of income of the respondent number 1. In absence of anything to the contrary, it can be presumed that the respondent number 1 is an able-bodied person. At the same time, it cannot be denied that the respondent number 1, being the husband and an able-bodied person, is liable to maintain his wife. Hence, the respondent number 1 is directed to pay rupees 8,000 per month as interim maintenance to the aggrieved person. That was made 4,000 by this Honorable High Court, and accordingly we are paying. It is also made clear that the observations made herein above are strictly for disposal of the prayer of interim relief to the aggrieved person only, and nothing contained therein shall be construed as an expression of opinion on any controversies between the parties or on the merits of the main application.
This is a interim order or final order?
Interim order.
Interim order.
Further, call for the domestic incident report from the protection officer. So while the notice was issued, issue notice to the respondents, namely all the 4 persons.
All the 4 petitions.
And domestic incident report was also called. Aggrieved person to take steps, furnish a copy of this order free of cost to the parties to the application and the officer in charge of the concerned police station, along with addresses of the aggrieved person and the respondent. I am not aggrieved by this order only, but I am aggrieved by the entire application filed by the aggrieved person. The allegations leveled are not constitute an offense under section 12. From the additional
In which case you think your contention is that in which case quashing would lie?
Yes, Lordship.
You are challenging the proceeding
Quashing.
itself.
So I have not filed any appeal against the order. I have directly come to Honorable High Court under 482 for quashing of the entire proceeding. Because there are 4 persons. The husband is the person who was residing with the aggrieved person in his quarter. Father-in-law is residing in, Lordship, the places I have stated that he was residing in Tinsukia maybe, and the mother-in-law was residing in Bihar with her daughter, and opposite party petitioner number 4 is sister-in-law who never seen the aggrieved person. She has not come to Assam to attend the marriage. She is a circle officer doing her job in Bihar. So the person who was never came to the Assam to attend the marriage has never seen the aggrieved person. Allegations are against her also. Looking into all these facts, the stay was granted and there was a direction to pay 4,000 to the wife. I am ready to pay. Monetary dispute I am not disputing. But in this case, the wife, thereafter the matter was sent to mediation center. There the husband and father-in-law came 2 times. My learned friend is aware of that. We have tried our level best to bring the aggrieved person, but she denied to come to Gauhati. We all tried, even we, I myself spoke, my learned friend spoke.
That is appreciable, really. But some things cannot be sorted out. They are very, she is not very.
And the petitioner number 4 is working in Bihar, that all the documents I have enclosed with my criminal petition. And the complaint petition from the additional affidavit, your lordship will find the prayers which are sought by the aggrieved person, page 82, annexure 6. It extra copy as a file. Page 84, that the aggrieved person filed this application under section 12 of the Protection of Women from Domestic Violence Act 2005. These are her details, and thereafter her claims are page 85, orders required. Prohibiting acts of domestic violence by granting an injunction against the respondents from repeating any of the acts mentioned in terms of column 4A, B, so and so of the application. Prohibiting respondents from entering the school, college, workplace. She is nowhere working, child is an infant. Prohibiting the respondents from stopping me from going to my place of employment. Earlier, she was a lecturer. After marriage, she became housewife. Prohibiting from stopping you from going to your school. No one is going to school. Prohibiting any form of communication by the respondent with you. Prohibition, alienation of assets, stridon, and other properties of the complaint by the respondent. Prohibiting operation of joint bank lockers accounts by the respondent and allowing the aggrieved person to operate the same. So joint bank account, she will operate, but I will not entitled to operate. Directing the respondent to stay away from the dependents, relatives, any other person of the aggrieved person to prohibit violence against him. Any other order, please specify. An order restraining respondents from dispossessing or throwing me out from the shared household. She herself left the house after birth of the child to her parental home. Entering that portion of the shared household in which I reside, alienating, disposing, encumbering the shared household, renouncing his right in the shared household, an order entitling me continued access to my personal effects, an order directing respondents to remove himself from the shared household. She herself removed herself from the shared household and now praying to remove myself from my shared household. These are the pairs. The entire petition is vague. Monetary relief under section 20, medical expenses amount claimed rupees 15,000. Thereafter, loss due to mental injury as specified 50,000. Total amount claimed 75,000. So it becomes 75,000 instead of 65,000. 15,000 and 50,000 will become 65,000. But instead of that, she claimed here 75,000. Monetary relief under section 20, food, cloth, medication under B clause, other basic necessities amount rupees 25,000. School fee and related expenses for an infant amount rupees 20,000. Just born child has date of birth. Not yet gone to school, school. 12 July 2023, child was born, girl, no? Girl child was born, and this case was filed on 24/24. So she is paying 20,000 for school expenses. My only fault is that I am an MBBS doctor. Household expenses amount rupees 10,000. Those I admit, no, my wife, my child, I want to pay. So these are the relief she sought for, and the allegations your lordship will find from page 89. That the aggrieved person is the wife of the respondent number 1. They solemnized their nikah on 16th of May 2022. Thereafter, respondent number 2 is the father-in-law and one person and father of respondent number 1. Respondent number 3 is the mother-in-law and respondent number 3 is the sister-in-law. That the husband of the aggrieved person herein referred to as respondent number 1 is a medical professional holding an MBBS degree and is currently employed at the community health center located at Ghilamara, Lakhimpur. On the other hand, the aggrieved person is a homemaker who maintains the household, including management of domestic affairs, preparing meals for her husband. So she admitted that she is a homemaker. There was no place of working, but in relief portion, she prayed not to disturb in her place of working. That the aggrieved person is deeply aggrieved with the severe and continuous acts of domestic violence inflicted upon her by all the respondents during her stay in her marital house and subsequently at the quarter allotted to respondent number 1 by the Community Health Center, Ghilamara, Lakhimpur. After marriage, only for 14 days she stayed in the matrimonial house where petitioner number 4 was never there. But her allegation is that upon her by all the respondents. All vague allegations that the acts and conducts of the respondent number 1 to 4 during their domestic relationship with the aggrieved person has created immense physical, emotional, and psychological trauma to the aggrieved person, putting her health, safety, and life in danger. As such, the aggrieved person has been compelled to institute this proceeding to get herself protected under the law. That a couple of days after the aggrieved person's marriage with the respondent number 1, that is on 16th of May 2022, respondent number 1 informed the aggrieved person of severe crucial information. So her allegation is that after a couple of days, but the date was mentioned, the date of marriage. So it says on the date of marriage, he himself disclosed crucial information that had been withheld from her prior to their marriage. The information is that respondent number 1 showed the aggrieved person a resignation letter and informed her that he was on the verge of resigning from his job, but due to family persuasion, he did not resign. These are the allegations for the aggrieved person. This cannot be termed as cruelty or lordship, any action taken against her. Furthermore, the respondent number 1 disclosed that he had been struggling with some mental health issues. He admitted to being a phone addict, for which he had to visit a psychiatrist. The psychiatrist advised him that he switch from a touch-screen Android phone to a keypad phone. The aggrieved person began to feel that she had been trapped in a conspiracy orchestrated by her husband's family. These are the allegations. That it began a few days after the marriage on 20th of May, after 4 days of marriage. The respondent number 1 was on a night duty at the CMC. At about 10 p.m., respondent number 3 called the aggrieved person into her room and asked her to sit on the bed. Unexpectedly, respondent number 3 grabbed the aggrieved person's phone, mother-in-law, which she had placed beside her on bed, and violently threw it on the bed and taunted the aggrieved person, "Itne saste mein nipta diya," which translates into "disposed of so cheaply," indicating her dissatisfaction with regards to the dowry. Following this, the respondent number 3 continued to belittle the aggrieved person by questioning, "What did your mama give? They happen to be rich, is not it? And what about your aunt, father's sister, who wears big gold goggles? What did she give?" That subsequently, the next day, that is on 21st May 2022, respondent number 4, who was in Bihar. So she admitted that respondent number 4 was in Bihar, called the aggrieved person and instructed her not to reveal or disclose anything said by her mother, respondent number 3, to the respondent number 1 or to her parents. That on 1st day of June 2022, respondent number 1, accompanied by the aggrieved person, shifted to the residential quarter allotted by the above-mentioned health center. So she herself admitted that only 14 days she resided in the matrimonial house, along with the family members. Concurrently, the mother-in-law of the aggrieved person, who had been residing with them up to this point, this is a false statement, moved to stay at her daughter's place. Up to this means up to the matrimonial house. Moved to stay at her daughter's place at Bihar. So mother-in-law was only with her till 14 days. Thereafter, she left for Bihar. So allegations against 1 to 4, but she herself admitted that opposite party number 4 was residing at Bihar. Mother-in-law only resided for 14 days with her, and then mother-in-law left for Bihar to reside with her daughter. And the respondent number 4 was pregnant at that time, Lordship, and after filing of this criminal petition, she gave birth to a child. And father-in-law resided at the matrimonial house, the original home, and she herself was living with her husband in the quarter. that few days after the aggrieved person and respondent number 1 settled into the health center provided quarter, the father-in-law came to visit them at their new residence. He stayed with them for an extended period during which his influence over the household became increasingly apparent. Over the course of his stay, respondent number 2's discussions with the respondent number 1 began to subtly influence the latter's thoughts and behavior. That one day respondent number 1 made a dangerous blunder. He administered wrong medication to a patient at the CHE, jeopardizing the health and safety of the patient involved. After returning to the quarter, respondent number 1 heedlessly expressed the wrongdoing to the aggrieved person. From this point onwards, aggrieved person and the respondent number 1 started to face a line of conflicts. So regarding medication to some patient, they started conflicts as per her statement. These are not allegations of under DV Act. That the aggrieved person experiencing persistent pain in her legs requested that respondent number 1 arrange for a medical evaluation at the CHE where the latter was appointed. However, the respondent number 1 assured the aggrieved person that it is a thyroid-related ailment despite the health center being fully equipped to conduct a thorough checkup, including thyroid testing. Respondent number 1 insisted that they travel to Dhokua Khana for the medical test. Upon arrival in Dhokua Khana, several tests were conducted and later on the test results were received. The result of the medical test was unexpected. The thyroid test, which respondent number 1 insisted upon, showed no abnormalities. However, the report indicated that the aggrieved person was on the verge of developing diabetes with her sugar levels nearing a critical threshold. Upon returning home, respondent number 1 shamelessly admitted that he knew that there were no thyroid-related issues as her menstrual cycle was regular. He revealed that his actual concern was her sugar levels. When the aggrieved person pointed out that sugar level testing was also available at the CHE, respondent number 1 immediately denied this fact. Later on 20th of January 2024, respondent number 1 confessed in front of the aggrieved person that the decision to have the aggrieved person tested for sugar levels was made solely based on his mother's instructions and that there was no independent medical reason for having the test. That while the aggrieved person was staying with her husband at the CHE provided quarter, her mother-in-law used to call her regularly and with great frequency every day. During these calls, respondent number 3 would often question, "Tum babu ko kaise shadi kar liya?" Lordship, how come you managed to marry my son? But this is an arranged marriage, she admitted. These calls became a daily source of stress and emotional distress for the aggrieved person. It is pertinent to mention herein that it was in fact the groom's respondent number 1's family who initiated the marriage proposal, expressing their interest in forming a matrimonial alliance, and that the aggrieved person and her family accepted the proposal in good faith, believing it to be a mutual and respectful decision. So when the respondent number's husband's family initiated the proposal, how come the mother-in-law taunt her like that, how you make my son to marry you? That further the respondent number 3, that is the mother-in-law of the aggrieved person, persistently used to harass and body shame the aggrieved person during her pregnancy. Lordship may read this part, paragraph 13.
Insensitive behavior.
Lordship. So
Something like-
these are the allegations, Lordship. Whether this constitute any offense under domestic violence Act. Most importantly, when all the 3 respondents are residing outside their quarter. In Bhajanlal, Lordship, it stated that, and there is a judgment of Supreme Court which says 498, Lordship, that is Anurag Vijay Kumar Goel in matrimonial
Should I
dispute.
write it down or will you give?
I have a copy of this, and Bhajan Lal also I
Sort
have
of,
a.
Tripathi, I'll take it out, no?
Lordship, I will give.
Huh? Okay. The allegations constitute domestic violence. That's a primary question for you. Domestic
Saurabh
violence.
Tripathi, I am handing over. I have the only one
If
copy.
they constitute the domestic violence, suppose, prima facie,
Lordship.
not to justify quashing. Of course, as he said, it will be whether they are truly domestic violence will be a matter of evidence. But prima facie, if they do not constitute domestic violence, then probably quashing jurisdiction can come
Yes,
as per the law. But if they prima facie constitute domestic violence and a court, a particular court, high court thinks that it should not be quashed, then your contention will come. Then in that case,
No, in that
they are aggrieved by this order, and then the appeal question might come.
in that case, Lordship, if I am aggrieved with that order, I am aggrieved with the entire petition of the wife. In Anurag Vijay Kumar Goel, that is a 498A proceeding, not DB Act, but Supreme Court said this is a 3-judge bench decision. In a 498A case, para 10, page 5. Surprisingly, Annexure P3, which is a statement on which the crime was registered on so-and-so, speaks of the appellant having left Bombay for Faridabad, and these are, it stated that allegations and counter-allegations. Apart, we perceive nothing more than ordinary marital squabbles, scheme races, and bickerings blown out of proportion, often leading to eternal strife, then entrenchment, and eventually divorce, as has been the trajectory in this case too. The fact remains that in the statement to the police dated so-and-so, when the respondent speaks of the appellant having abandoned her, so there also the Supreme Court says that these are vague statements. Paragraph 11, there were multiple proceedings pending against the appellant filed by the respondent when the appellant approached the family court at Mumbai for divorce, in which the mediation was held and there was a settlement entered into at Annexure P10. Annexure P10 dated so-and-so spelled out the clear terms on which the parties decided to separate by way of a legal divorce on mutual consent. It specifically referred to the various proceedings between the parties which were agreed to be withdrawn after passing of the final decree of divorce. It was also agreed that no further civil or criminal cases would be filed against each other. The agreement required a deed to be executed and registered by the appellant gifting the apartment in Mumbai to the respondent, prior to which the respondent also agreed to clear the outstanding loan with a bank wherein the apartment was mortgaged. These are the agreement details between both the parties. Paragraph 12. In paragraph 47 of the additional reply, the respondent has admitted that the maintenance due to the society. Paragraph 13, Your Lordship may come. These are the facts of that case. Paragraph 13, we have already found that the allegations in the statement of 19/4/2018, based on which the crime was registered against the appellant inter alia under section 498A, are commonplace, banal, and vague without any specific instances mentioned and filed 1 year after the admitted separation of the couple.
Anyway, so I think we are running out of time also.
Yes.
So will you complete? We'll have to. We'll have to keep it part
Part-heard, Your Lordship may fix part-heard and fix on any date.
You wanted to say something?
Allegations are there, so without going into evidence, come out.
No, this Saurabh Shukla also said the exceptional that suppose even if you accept the allegations, they do not make out any offense of domestic violence, suppose. Or they cannot make out, suppose. Then maybe, yes. Oh, that has to be seen. That I have to see. My work will be that. But anyway,
my case is I am ready to pay maintenance to my wife and child. I am ready. But these allegations is affecting my career.
You know, actually.
Where he has also said about that where her stitches have still fresh when he has cut at all. So those are also there.
But sister-in-law and father-in-law, we have to see more carefully, perhaps. So
And during the mediation, she herself admitted that I have no allegation against my husband.
Huh. So anyway, good. If that, see, the thing is that, of course, you know that, a maintenance, it is not a normal maintenance like 125. Maintenance under a DV proceeding is actually a monetary relief.
Yes.
And any relief under DV Act is contingent on on commission of domestic violence. The basic jurisdiction comes from that. There has to be domestic violence. Suppose somebody wants a maintenance, suppose wrongly, she comes before under the DV Act, then forcefully she has to prove a domestic violence case, which may not be proved.
Yes,
But
there is no bar. She can file 125.
pure maintenance issue is when she is unable to maintain herself. But here, it is not a maintenance due to not being able to maintain herself. It is a monetary relief, due to commission of domestic violence. That
Some offense.
as a relief it has been given.
First, they show that there is an offense by the husband. Before vacation.
There are certain allegations she has made.
Yes, that we have to see.
Yes.
R. Chaudhary. I'm not expressing any mind. We are just discussing the principles. The R. Chaudhary Learned Counsel appearing for the petitioner. Full stop. MDV Learned Counsel. LDV, right? LDV Learned Counsel. Legal aid counsel for the respondents / aggrieved person. Full stop. Arguments were addressed but could not be completed due to paucity of time. The matter may be kept as part heard. Part heard to bold. When should we fix it?
Before vacation or after vacation?
No, after vacation.
After vacation.
Only 2 days left. List
Then
is also
27th April.
27th April or
Monday.
or Monday.
Monday, Lordship. Otherwise, we may.
22nd. If I don't know the roster, I have not seen it. It's coming today or tomorrow. I see. Nothing. Put yet. Oh, Kohima. So I'll be in Kohima for 2 weeks after, from 28th. So it has to be after that.
For 2 weeks, maybe your Lordship is out
Yes.
like that.
That was my concern actually.
After
it will
after
delay
giving
you.
that to when then
Delay you.
Lordship, 4th of May, this is a Monday, May, after 2 weeks. After vacation, after 2 weeks, then 3rd week.
4th of May. 4th or
The
6th.
4th is a holiday.
4th of May is a Monday.
No, it is a holiday. There's some holiday, no? Mr. Sharma? We have not fixed matters. 4th is a holiday, I think. But it is a holiday. Tolot ase. No, not you to count. Don't.
Counting as a no.
But it should be a holiday, no, for counting. But anyway.
Or 5th
Well-
May at 2 p.m. Lordship. 5th May at 2 p.m. No, at 2 hola ma hese jabo.
Let us fix it on 8th. We'll try to accommodate. No?
At 2
It is
p.m. At 2 p.m.
We'll not say that. We'll adjust. Suppose it does not reach on 8, then on the week thereafter, we'll fix on a day at 2 p.m. Huh?
And looking into the cost list, if your Lordship gave us permission, then we can upgrade also on that day.
Yeah, on that day also we can update. That day also we can update. Because since it will come for me only, so we can upgrade. কি holiday আছে? There's some holiday on 4th. জানিছিলো কি but আছে কি আছে মনত আছে।
My lord, our matter may be.
Sorry,
My lord.
your matter, please take a date as per your convenience. Huh? Please take a date. I thought we might have a chance, but proceeded to the merits.